Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Massachusetts Appeals Court on this Thursday, October 9th, 2025, which apparently is Leif Erikson Day. I am Justice Ditkoff. To my right is Justice D'Angelo. To my left is Justice Wood, and we'll be the panel for all the cases today. I know many of you are experienced, but not all of you, so I'll run through the ground rules. We have a clock here. Each side gets 15 minutes. When 90 seconds are left, the light will turn yellow, and then when time runs out, the light will turn red, and we'll start counting up. If it's red, that's not how much time you have left. That's how much time you're over. If the light hits red, finish your sentence, but don't say anything else unless you're answering a question from one of the judges, in which case please do complete your answer. There's no rebuttal in the Massachusetts Appeals Court. I assure you we have read the briefs. We've looked through the record and we understand what your case is about, so you might as well just jump right to your argument. So with all that having been said, I'll call our first case today, which is Commonwealth versus CRAMER, number 24P 1253. Counselor, whenever you're ready.
Thank you, Judge. Good morning. May it please the court, Justice Ditkoff. My name is Attorney Adam Oos. I represent Philip CRAMER. Your Honors, the two photographs in this case of my client's daughter were not probative on the issue of the complainant's age and size because they didn't create a link in the chain of proof. And that is what we argue is the essence of probative value. It is evidence that makes something more or less probable than it would be without said evidence.
Well, I mean, if you look at the kindergarten photo and then you look at the fourth grade photo, you can infer a lot from those. And I think the first thing that jumped out at me, kind of like a truck, was the kindergarten photo. Even though I couldn't see her, it's true I couldn't see her whole body, and so I couldn't get a sense of her full size, you could very easily infer very strongly, she's young, she's little. That's bad.
You know, it's funny that you say like a truck, because when I got this case and I was first looking at those photos, my thought, what are these doing here? What's the point of this?
Well, because the relevance, the first question in this analysis, you know it as well as I do, is relevance. It has to be relevant, 401. Mm-hmm. And what's the point? That sounds to me like a relevance question. And to me, I think I just answered it, she's little.
But I think you also proved my point, because you said, oh, that's bad. And if you're having some kind of visceral reaction to these photographs, I think that speaks to the prejudicial nature of them.
Well, isn't all evidence that the Commonwealth wants to put in against a defendant bad?
I'm sorry?
Isn't all evidence that the Commonwealth wants to put in against a defendant bad, or else they wouldn't put it in, would they? I mean, it's not just that it's prejudicial. I mean, again, all evidence that the Commonwealth introduces against the defendant, it's prejudicial. That's not what 401 and 403 preclude.
No, but the Commonwealth doesn't, by that same logic, the Commonwealth doesn't get to put in evidence simply because they like it either.
Agreed. It has to be relevant to an issue. And an issue in this case, as in all rapes, is physical force, constructive force, or threat of force. Mm-hmm. So why doesn't the size of the child, which I agree with my colleague, is at least somewhat in those pictures, why doesn't that go to one of those types of force? Why isn't it relevant to one of those types of force?
Well, there's a couple of points here. I think as I was coming in this morning, I was thinking about this, and I think the point that I'm trying to make here is that these photos have no intrinsic value with respect to, A, the relative size of the complainant to the defendant, and that's what matters. It's not just that you look at her and say she's small, it's that relative size. And these photos, if they have any probative value at all, it's minimal as to her size generally, but not to anything else.
It would have been okay if they had a picture of her in kindergarten that was from feet to head in a school uniform. That would have been okay. It's only because it's the face that's showing that makes it not okay?
No, because also in my brief I talk about the fact that these are labeled as school photos, and I think again that goes to the prejudicial nature of the photographs. So even if they have some minimum probative value, even if, they had some minimal probative value on size, I think, because these are school photos. And I think that would actually have made it much worse because she's in her school uniform. She's not in a uniform in these photographs, but she is, as I argued in my brief, done up for this carefully curated photo that's been labeled school photo.
Was there a limiting instruction given?
There was.
And also the Commonwealth argued it for the purpose by which we're talking about here of using the photo for the relative size. Doesn't that cut against your argument that it was being introduced for merely a prejudicial reason? Both of those, that are a limiting instruction, and that's why the Commonwealth specifically argued it that way?
As to the limiting instruction, there's only one. We argued that the limiting instruction didn't work, and there's only one metric that case law seems to accept as to whether the limiting instruction worked, and that's whether the jury found not guilty or acquitted on some charges but not others. Whenever there's a case, I wish I could come up with one in the moment, but it's in my brief that if the jury acquits on some charges, they say, well, it looks like the jury was able to fairly sort these things out. That didn't happen here. So I would argue first with respect to the effective efficacy of the limiting instruction, the Commonwealth can't prove that that instruction worked because that is not there. And I'm sorry, Justice Angelo, I've forgotten the other half of your question.
It was the fact that the Commonwealth argued it in their closing for the purpose by which we're talking about here, the relative size. So any prejudice that you're suggesting, isn't it that the Commonwealth sort of went away from any prejudicial argument and focused purely on the probative part of the picture?
Well, they can argue it all they want, Your Honor, but the fact of the matter is we argued that it wasn't probative of those things, primarily because of the relative size issue, as to one. And then as far as the age goes, and this goes back to my point about this being in no intrinsic value, is that if it was just the photograph, it doesn't bring anything to the jury's understanding of the case. In fact,
well,
we needed evidence. I'm sorry.
I guess I'm not really accepting that she was 13 at the time she testified. She was I guess a young adolescent, I'm not sure, but a teenager. She was a teenager. And the allegations were from ages 5 to 10 or 8, 5, something like that.
She said 11 or 12.
Okay, but certainly a 5-year-old is a lot different than a 13-year-old. So a jury looking at this complaining witness is going to see somebody very different than the victim in the beginning, or the complaining witness at the beginning of this time frame. And it seems, I mean, on the very low standard of relevance that and there was no stipulation here, that showing that photo, you immediately understand in a very clear and simple way, this person I'm looking at here is different than the person testifying in court. So why isn't that enough to at least clearly establish relevance? So when you say no intrinsic value, to me, that's a clear intrinsic value.
Because as trial counsel argued below, and I repeat his argument, the jury can look at the witness. She says, I'm this old, this is when it began, this is when it ended, and it is for the jury to accept or reject that testimony. And just as you said to me earlier in the argument, oh, I can look at this picture and infer size. Well, as trial counsel said below, anybody can picture a 5-year-old. Anybody, they can look at her and say, well, being a 5-year-old is inevitable at some point. I don't mean to make light of the fact, but it's within the jury's ability to infer that she was smaller, that she was younger, based on her testimony.
They don't have to. I mean, we hear this all the time. The Commonwealth is not required to leave it to the jury to infer things that are obvious. The Commonwealth is entitled to present its case. The Commonwealth is entitled, if this is one of the issues of force in a rape charge, and constructive force, they're entitled to hammer the point home with relevant evidence and not leave it up to the jury to infer.
Well, the jury shouldn't be speculating, but I think we allow juries to make reasonable inferences all the time. And I think in this case, jury can infer that this person, based on her testimony, was younger at some point. But the photographs themselves don't help. I guess the point I'm trying to make is that the photographs, and this is what I want this panel to consider, is how do these photographs fill in a hole that the jury wouldn't understand otherwise? You know, in the homicide cases that are all over my sister's brief and my brief, photos come in because they help the jury understand something that they can't necessarily infer. You know, intent doesn't have, you know, in a murder case doesn't have, you can't see it. So we have to put in these photographs to help the jury understand extreme atrocity, to help the jury understand the person's intent. These photos,
one of the frustrations of being an appellate court judge is that the Superior Court judge is seeing the victim and can say how much different, can see how much different this victim looks than these pictures. And we don't get to do that, which makes it hard for us to challenge the judge's discretion. Is there anything in this record that gives us some sense of how different these pictures are from how the victim presented as testifying? I didn't see it, but I could have certainly missed it.
Understanding the...
Is there some description of her? Is there some way we would know how mature or how old she looked on the stand? I didn't see it. There wouldn't necessarily be there, but if there is something that I missed, it would be really helpful.
You mean on the record? Is there some...
that we could see.
Nothing leaps to mind.
Yeah, I didn't see it.
Other than the fact that she says, I'm in 8th grade now, right? And, you know, I don't know that it's for this court to compare her size. Even, I mean, I think the point is it's not for this court to compare her size at trial to those photos. Because I think that starts to get into the element that the trial prosecutor tried to bring these photos in for the purposes of her development, which I think takes us down a dangerous road of proclivity evidence, which is what trial counsel was trying to argue against. I think the point is to look at these photos and say, do they help the jury understand something about her size at the time of the alleged abuse relative to the defendant, not relative to her size on the stand?
Can I ask, I want to switch to the 403 question. So let's assume that we reject your argument that it's not at least relevant enough to satisfy 401. The other implication of my initial question about it hitting me like a truck is obviously, and I think you understood this, 403, prejudice. You look at that first photo and you know the facts of the case as alleged, and it breaks your heart. And you immediately think, ooh, that's powerful. Mm-hmm. But and Justice D'Angelo makes the crucial distinction. It's prejudicial evidence is okay. It has to be unfair prejudice. That's what 403 is about. Mm-hmm. I'm having a hard time in my own mind articulating why this was, where the line is in this specific fact pattern, in this specific photograph between fair prejudice and unfair prejudice.
Well, I think your gut reaction proves the unfair prejudice here. I mean, you know, I'm not trying to be flippant, but, you know, I think if we look at this photo and you have any kind of that visceral reaction, you know, a photo doesn't need to be gruesome to be inflammatory or overly sympathetic or unfairly prejudicial, lots of words. You know, that visceral reaction, we're all lawyers in this room. We deal with hard facts a lot of the time, and we are, I'd like to think, fairly good at separating ourselves, but the lay persons of the jury might not be. Particularly in a case like this, where we're already dealing with an emotional case, we're dealing with alarming allegations of father raping his own daughter, we're dealing with my client's dissociative disorder, divorce. These are hard topics. The complaining witness was crying on the stand and needed a number of breaks. So into this mix comes these photos that I think, as trial counsel argued, are highly endearing, are evocative of school memories, might even evoke memories of one's own child and that sort of protective, instinctive nature.
You keep saying school photo.
Yeah.
And I'm failing to see why, because it's a school photo, it's more prejudicial. So it would have been okay if it was a picture of her at the playground. It would have been okay if it was a picture of her with her family. I mean, this is, I know it says school photo, but it's a non-discrete photo of her as she appeared in one of those school photos. Mm-hmm. So why is it the fact that it's a school photo raising the higher issue that's prejudicial? I'm missing that.
There's 2 points. I think one, the point is the reason I raised the school photo issue is because that speaks to the judge's abuse of discretion here, is that there were more steps the judge could have taken, other than just excluding 4 photos as overkill. The judge could have said, there's more she could have done to reduce the level of prejudice, and I think where it's clearly labeled as
Like
a school
what?
photo. I'm sorry?
Like what?
Like removing
to
the labels of
jury,
school photo.
They could have redacted school photo?
We redact mug shots to prevent.
But again, that's where I'm getting, why is the fact that it's a school photo so prejudicial?
I think the best answer I have for you, Justice D'Angelo, is to repeat what trial counsel said, is that it evokes memories of a certain time. I think these are, they're endearing photographs, and
Can I switch something for a sec?
Yeah.
You mentioned murder cases, and both you and counsel have put in some cases, but the cases you put in are about post-mortem. The Commonwealth is almost, I won't say always, but almost always allowed to introduce a photo of the victim pre-death. Just a picture of a victim. And this is the person that died, and this is what the victim looked like when they were alive. Why is that not overly prejudicial versus this?
well, I'm not arguing that case, Your Honor, so
But it's routinely allowed, not just in the trial court. The SJC has said that's okay numerous times.
Well, first of all, I would caution us against looking at this case in generic terms or in a legal vacuum. Like, so they're allowed, so they're allowed. I think that's circular logic, where it's allowed elsewhere, so they're allowed here. But to address your point specifically, Your Honor, I think in those cases there might be a situation where, we have this post-mortem photograph and we want to help the jury understand something about the person when they were still alive. That's not the case here. That's distinguished.
All right. Thank you, Counselor.
Thank you, Your Honors.
We'll hear from the Commonwealth now. Counselor, whenever you're ready.
May it please the Court, my name is Casey Sylvia. I'm an Assistant District Attorney for Middlesex, arguing on behalf of the Commonwealth. Your Honors, the judge did not abuse her discretion here in admitting just 2 photographs of the 5 that the Commonwealth initially offered of the victim, depicting her size and appearance during the relevant time period when the defendant was assaulting her. The photos were obviously most relevant to the element of constructive force, which is an element that the Commonwealth must prove. Well, let me stop. The Commonwealth, of course, must prove force. And one way to do that is to prove constructive force. Some of the rapes that were alleged did involve physical force, but some of them did not. And
Counsel, let me go to a point that your opposing counsel sort of suggested. It really wasn't a contested issue at all in the case that, and this is what I mean by it wasn't contested. If she's 5 and the defendant is an adult, is there any question in anyone's mind in that courtroom that the defendant was bigger than a 5-year-old?
I understand your point, Your Honor, but it is still an element that the Commonwealth has to prove. It wasn't something that was stipulated to. I'd point out that I think it's Commonwealth v. Targic, that there actually was, in the footnotes, I just noticed this the other day, that one of the forcible rapes of a child, the defendant was found not guilty on the forcible piece of it. He was convicted of the lesser included, and that was a 10-year-old. And I can't tell for sure from the decision, but it looked to me like the 13-year-old victim, there were photos submitted of her, the defendant was convicted of a forcible rape of a child on those counts, and then is found not guilty of the forcible piece, or at least is found guilty of the lesser included on the 10-year-old. And so to me that suggests that there are situations where a jury might believe that the defendant did what he was accused of doing, but that the Commonwealth had failed to meet its burden of showing constructive force, even when the child, a 10-year-old is fairly young. I mean, is the age of the victim during at least some of the period of the assaults here. So I do think it was relevant for the jury to see the actual size and appearance of the victim during the time span of the assaults. I think perhaps what I'm about to say could cut both ways, but I think there's a reason that people say that a picture is worth 1,000 words, right? That no matter how many things you say on the stand to try to convey what a person looked like, it's different when you actually see them. And I have to say, when I initially saw the photos, one thing I was struck by, obviously the victim when she was 5 was quite small. I'm not particularly familiar, I don't have children, I'm not particularly familiar with children. There could have been people like me on that jury that are not around 5-year-olds all the time. But what I was struck by is that she actually looked quite a lot bigger when she was 9. To me, I thought that she looked a little older than I would have expected for a 9-year-old. And obviously that's just me, but, and it's up to you to review the photos and.
So I'm going to give you the same question I gave your opponent. That is all describing exactly how emotionally it hit me. When the contrast that you just articulated between the 5-year-old and the 9-year-old, it helped me, both, it was a double-edged sword. I thought that actually was helpful on relevance, but I understood in a visceral way the argument that the defense is making in a way that I didn't on the page, because the picture's worth 1,000 words. Oh my goodness, this is bad. So unfair prejudice, how do you address unfair prejudice? Why is it not unfair?
Right, and I think that what you're describing is exactly the balancing test, right? Because you do kind of have this visceral reaction to the photos. And so at that point, the judge, and I think the judge pretty clearly did this, balances it against the prejudice. And I just don't think there's anything uniquely prejudicial about these photos, right? The reality is the victim was that age when the defendant was alleged to have assaulted her repeatedly. But to the extent that they were prejudicial in some way, I think the way that you address the danger of unfair prejudice is what the judge did, which is first she questioned the jury about whether they would be able to be, fair and impartial. She instructed the jury to focus on the evidence. This is before they're impaneled. This is before the trial began, once they were impaneled. She instructed the jury to focus on the evidence and do your best to resolve this case based on the evidence and the law without sympathy, bias, or prejudice to the best of your ability as human beings. When the evidence came in, she gave another contemporaneous instruction to the effect of, we're going to put it in, these photos are going to come in showing the victim's size. They're going in to help you understand her age and size at the time of the alleged incidents, and that it's natural to feel sympathy, but you can't decide the case on that basis. And then again, during closing jury instructions, the judge again specifically instructed with regards to the photographs.
So that's very helpful. All three of them, I take your point. The judge did a really good job doing the best she could there. Am I right that this is a pure credibility contest? There was the corroboration, to the extent there was any, was a first complaint witness who, in any event, even if it is useful testimony, it's still it still goes to the credibility of the complaining witness, right?
Yes. Yeah.
So it's purely a credibility contest. So the danger here is, as the judge identifies it for the jury, letting this create unfair prejudice and sympathy for the complainant. And I think the case law indicates that those dangers are especially dangerous where you have pure credibility contests. So do you agree with that? Or is there a problem here because this is a pure credibility contest and the danger here is very specifically unfair prejudice or sympathy?
So I could see a situation where that could be the case. I just, when it comes to these particular photos, I have a hard time seeing that. They're quite, despite the fact that, again, the victim is obviously young in them, they're kind of the childhood equivalent of R&B photos. They have bland backgrounds. It's only the upper half of the body. There's no props. It's not the full body of her in her uniform. It's just, I have a hard time seeing, even if there might be a case where, based on the fact it's a credibility contest, that putting in overly sympathetic photos would sort of push the jury too far in the direction against the defendant unfairly.
Let me ask one more question. The defense counsel, doing his or her, I can't remember as a man or woman, job correctly, objected vociferously. So now it's a prejudicial error standard. The most prejudicial, it's a pure credibility contest. The danger is unfair prejudice. You're saying, nevertheless, your position doesn't change, I guess, that it doesn't even meet that lowest standard prejudicial error. There's no danger here that this jury would have come to a different conclusion but for the introduction of these photos.
Yes, Your Honor. I think as the panel already acknowledged, all evidence is prejudicial, obviously, that the Commonwealth puts in. The only question is whether it was unfairly prejudicial. I do not think that there was anything uniquely or unfairly prejudicial about these particular photos. When we look at the cases the cases that have to do with photos, obviously there are two that I cite in my brief, I believe, that specifically involve photos of rape victims. In one case, they were poster-sized photos of the 13-year-old victim that were put up in the courtroom, and that was still held to be properly admitted. But when you look at the homicide cases, I find it hard to believe that photos like this, pretty bland, sanitized photos, only two of them, that this should result in reversible error, that it prejudiced the defendant so badly that a jury just could not be fair and impartial to him after seeing them. When we have photos that are admitted in a case like Commonwealth v. Kyle Lane, that you have 18 or 19 pretty graphic autopsy photos that are admitted, and the judge does not give a contemporaneous limiting instruction, and the SJC still upholds that case. I find it hard to believe in the face of case law like that, that these two relatively bland photographs would result in the type of prejudice necessary to reverse a conviction.
This would be a pretty different case if there was giant posters.
What's that? I'm sorry?
I think this would be a pretty different case if your predecessor had made giant posters of these pictures.
Yes, Your Honor, I think that's probably true. When I was struck by that in that case, the fact that they were giant poster-sized photos, as opposed to being briefly put up on the Elmo and then taken down in this case. But I do agree it would be a different case in that situation. But if there are no further questions from the panel, I would rest my brief, and I would just ask that you affirm the defendant's convictions for forcible rape of a child, aggravated rape of a child, and indecent assault and battery. Thank you.
Thank you, Counselor. Thank you both. A very interesting case, and we'll take it under advisement. We'll just let your friend get situated. All right, calling the next case, Commonwealth versus Sam, number 24P1006. I should have said it's the last case. Just remind everyone that we're not going to name the victim in argument. I'm sure you know that, but just for the record. Whenever you're ready, Counselor.
Thank you. May it please the Court. My name is Lisa Medeiros, and I represent Mr. VICENTE Sam. Your Honors, I'd like to start off with the failure of counsel to investigate the first complaint witness. In Commonwealth versus Perez, the Court stated that it's a constitutional mandate in both Massachusetts and the federal Constitution that requires trial counsel to conduct an independent investigation into the facts.
Right, so good. That's where most of my questions are. So right off the bat, did you or I don't know who did there was an evidentiary hearing on the new trial motion, right?
Correct.
And I don't believe I saw, but please correct me or direct me there, an affidavit from this first complaint witness, Alicia.
There was no information. Alicia was never located.
Okay, right. And so she didn't testify. She certainly didn't submit an affidavit, and she didn't testify at the evidentiary hearing.
Correct.
So, right. So, unlike Perez, I saw your brief, I went back and read Perez, and as I expected, Perez is very different. In Perez, first of all, there had been a first trial, and they knew what this other witness was going to testify to because he or she had testified in the first case and given an alibi. And inexplicably, frankly, in the retrial, new counsel, who had only gotten the trial transcript at the last second before the retrial, doesn't know this and doesn't call that witness. And we all know what that witness is going to say. So that's wildly different than this case, where we don't know what Alicia's going to say, and it's speculation. So I'm struggling to understand how we could reverse a conviction, find under the ineffective assistance standard, second prong, prejudice, find prejudice sufficient to warrant reversal, where we don't even know what she was going to say.
Well, I would suggest that the standard here isn't about whether or not Alicia's testimony would have definitely been helpful to the defendant.
It's not?
Well, I think it would have been helpful, and I.
How do you know that?
Well, partially because of what happened when the Commonwealth 2 months before trial, notified trial counsel that they wanted to switch the first complaint witness. So I would suggest that should have been a red flag to trial counsel. Wait a minute, something's up with this first complaint witness. And certainly, trial counsel had an obligation.
Wasn't what was up with the first complaint witness was that the Commonwealth hadn't found her?
Excuse me, sir?
Isn't what was up with the first complaint witness was that the Commonwealth hadn't found her?
Well, okay.
That's what she says. I haven't found her, not in contact with her.
But trial counsel argued against the substitution of the first complaint witness, arguing that it was because Alicia was not unavailable, because they knew Alicia lived in the Blue Meadows housing project, they knew the street she lived on, they knew her last name, the victim's mother and Alicia's mother were friends, and Mr. Sam was on the street, so he could have shown where he dropped the victim off for the pool party, which is Alicia's house.
You say that, but how do we know that defense counsel could have found the first complaint witness? You couldn't. I know it was later, but don't you have to show, at the very least, that if counsel had investigated, they would have found the person?
Well, I don't believe so. I think that counsel's lack of effort, the very rudimentary effort of asking the investigator in their office to go out and try to see if you can find Alicia, to find out if she has anything helpful for the defense.
Okay,
So
sorry, I apologize, go ahead.
So that's first prong, but how do you satisfy the second prong of ineffectiveness?
Well, I would go back to what the Commonwealth's comment was on the first day of trial, that says that we believe, the reason we want to substitute is because we believe that Alicia is going to minimize the complaint of the victim. And I would suggest that that indicates that Alicia's testimony would have been helpful for the defendant.
Okay, can I focus on that for a second? So let's assume the witness was found. A lot of assumptions there. Let's
correct.
assume that the first complaint witness was going to have some quote-unquote discrepancies with what the victim would testify at trial. So defense counsel is going to put on a witness to at least corroborate something that the victim says, as opposed to just leaving that witness completely out of the trial, as it was here. There was no corroboration for this victim. You're going to put a witness on to corroborate some things, but not others?
Well, I don't know, because there was no investigation and nobody talked to Alicia.
That's the whole thing, is even if it was partially exculpatory,
Well, but
it's still going to be inculpatory.
But that's still, that's the problem, and that's exactly the problem I'm getting at. Because Alicia had never been interviewed, maybe what she had to say was completely opposite of what the victim was saying. We don't know that. She might have gotten up there and said something completely different.
So can I ask, we have rules, and one of the big rules we have to follow is we have to follow precedent. You cited Perez. Is there another case that you can direct us to in any court, anywhere, where that you're speculating in this way about whether this uncalled witness would have been helpful or harmful?
No, I don't have a case directly on point like that.
Okay.
But I guess the way that I'm picturing this is not, we don't know what Alicia would have to say, and there is speculation there. But the fact that trial counsel didn't make the effort to do it is what my argument is, and that is the ineffective piece.
Isn't there a risk when there's a witness that's helpful to the Commonwealth that the Commonwealth has not contacted, that if you send an investigator over to talk to them about the case, that it might cause them to contact the prosecutor and then wind up being a witness? Why isn't that a risk? That seemed to be what O'Regan was saying in the suppression hearing, was something she was worried about, that she didn't want the prosecutor to get information about her.
Right. Well,
Why isn't that a risk?
Well, she was saying that she believed that the first, yeah, and I think it's just because she was called the first complaint witness, trial counsel had a belief that the information that Alicia would provide would be more helpful to the Commonwealth, just because she was first complaint witness. And I think that was based on nothing. I think that she had nothing to support that belief, and that's the problem. So if she had sent out her investigator to talk to Alicia, yeah, I guess you always take a gamble when you talk to a witness because you unearth that witness, but she wouldn't have to disclose that to the Commonwealth. She can send her investigator out, conduct her investigation, find out what the witness had to say. The defense attorney had no obligation to notify the Commonwealth.
And if that witness then contacts the prosecutor, because obviously she wouldn't even know there was a trial going on since no one had contacted her, would that be ineffective, having sent that investigator?
No, I don't think so, because there's a duty to investigate to find out what she has to say, and that's a risk that we all take when we talk to witnesses. But I think that Without an independent investigation into Alicia's testimony, there was no way to determine how to proceed with this witness.
Is there anything in discovery at all about what either the victim said she said to Alicia or what Alicia says the victim said to her?
That's the problem, Justice D'Angelo, is that there was nothing in discovery that could indicate what Alicia would have to say. Nothing. Not a police report with a summary. No one had interviewed her. That's the problem.
So let's just say you were to win and this case were remanded. In light of the fact that your investigator couldn't find her and the Commonwealth couldn't find her, and you get a do-over, assuming the facts don't change, the trial is going to be exactly the same?
No. And the reason it wouldn't be exactly the same because of the other issues I've raised.
Well, okay, put all the other issues to the side. On this issue, because prejudice is the question, you're only entitled to reversal on this issue if you demonstrate prejudice on this issue, then everybody seems to agree that the trial would be exactly the same on this issue.
Well, unless so when I had my investigator go out to try to find Alicia, I didn't have the benefit of having Mr. Sam on the street. And I asked him to describe where she lived, and he wasn't able to identify the street name. He's just telling me it was near a store. The trial counsel did have the advantage of having Mr. Sam on the street, so they could have taken Mr. Sam and said, let's drive over there, and let's point out that...
All right, so maybe you could...
There's another maybe,
in
right.
a retrial, you could...
Maybe.
Prior to the retrial, you could find her.
And maybe we could find her, but what I had was, a name, a housing complex, and 3 years later. So there wasn't much hope in finding her at that point. But with Mr. Sam's assistance, maybe we could.
Can I switch to one other issue quickly? The first complaint testimony of the mother.
Yes.
I think I'm recalling correctly that the trial counsel testified at the evidentiary hearing, my mistake, I dropped the ball. No tactical decision, I just missed that one. That's on me. So that's helpful to you. But I think the problem I see is, again, precedent. I couldn't find any case anywhere, my clerk and intern helped me, we couldn't find any case anywhere where you get reversible error for this kind of first complaint mistake.
Well, actually, I think...
And I strike that. It's not actually a first complaint. That's the whole point. She was not the first complaint witness because the judge ruled that they didn't prove that Alicia was unavailable. So this testimony was clearly inadmissible. So the question is there a case finding that inadmissible, the admission of a reversible error based on that you know what I'm asking?
So I think that the cases that I cited, and I don't want to take the time to try to find my notes, the cases that I cited talking about, the reason I think I'm calling it first complaint witness evidence, because it says, according to the mother, and then there's a whole paragraph about what the victim's allegations were. And that would have been her first complaint testimony had the trial judge not precluded her from testifying as the first complaint witness.
Clearly not first complaint, clearly inadmissible. Right. The point is.
But the reason I'm calling it first complaint is because that was what she would have testified if she had been labeled the first complaint witness.
Right. And I mean, yeah, we're on the same page there. My question is very narrow. Has that ever been deemed reversible error by an appellate court? Reversible.
Well, but I don't have that. I don't have a case that says that this was reversible error because there was first complaint evidence in the medical records. I don't have a case that says that. However, in this case, because the entire case hinged on the victim's credibility, this was so prejudicial to allow that first complaint evidence to come into evidence through those medical records because it essentially was allowing the first complaint witness to testify to what she would have said without the opportunity of Mr. Sam having an ability to cross-examine her, ask for a limiting instruction, or give the jurors instruction on how that evidence could be used, the limitations on that evidence. So I would suggest that the fact that they came in this particular case with no evidence other than the victim's testimony, so her credibility was the entire case. There were no injuries to support her allegations, there was no forensic evidence, no independent witnesses because the one independent witness didn't testify, which was Alicia. So in this case, I would suggest that it's a perfect case to determine that this was inadmissible, and the outcome of the trial would have been different had this inadmissible, what I'm calling first complaint evidence, not been presented to the jurors.
Did the Commonwealth argue anything about that in their argument regarding the medical records, about what Mom said or anything like that?
In the Commonwealth's brief?
No, in their argument, in closing argument, to focus in on the jury.
No.
You can look. That would be a different case, wouldn't it?
No. Well, yes, but I still think it was so egregious in this particular case because of all the reasons that I've listed.
Do you feel, or can you argue that the Commonwealth did it deliberately?
No, no, because I'm putting this on the defense counsel. I mean, putting that record in.
But the Commonwealth's the proponent of the evidence. They know what's in the medical records. The judge had excluded first complaint testimony of the mother. And I agree with you, this is tantamount to first complaint testimony. It just, instead of the witness being on the witness stand, it came in through the medical records. So as the proponent of the evidence, is this sort of fall on the Commonwealth and not just the defense lawyer?
I would agree. I would agree. I guess the Commonwealth does have some responsibility here because they, at least I'm supposing that the Commonwealth took the opportunity to review the medical records prior to trial, which trial counsel said she didn't do. And that alone, I think, is what gets us here. And when you add that first complaint testimony to the sexual assault words, I mean, those don't come in. But they came in, and they came in twice, and they were in capital letters on one of the records.
Again, frankly, and I know there's case law about it, the fact that it says sexual assault, that's obviously why a victim goes to the hospital in this circumstance. The fact that it's there, to me, maybe error, but ridiculous. In this case, specifically excluding Mom from testifying, and then it shows up in the medical records, frankly, I don't know how defense counsel missed that.
Because she didn't look at them, Justice D'Angelo.
Well, but she did because she moved to redact other things.
Well,
she said she did. So, I mean, again, I don't know what she read and what she didn't read, but I hear your argument on that.
And that's why I'm saying that clearly is ineffective. I only have 37 seconds. I don't know if I should try to get into the CVS video or rest on my papers.
Well, it's very bad luck that the last case was all about keeping out pictures of the child being younger.
I was going to try to twist some of the justice's words, but I wasn't smart enough to be able to get that done. So then I will rest on my papers for the rest of the, thank you very much. I appreciate your time.
Thank you, Counselor. Hear from the Commonwealth now. Whenever you're ready, Counselor.
Thank you. Good morning. May it please the court. Stephen Nadeau on behalf of the Commonwealth. Unless the court has a different preference, I'll begin with the defendant's claims regarding the hospital records.
With the what? Case. I'm sorry, what?
With the hospital.
The hospital records.
Yes,
claims.
please do that.
Here, it was a cornerstone of the defense to rely on these records for the lack of physical corroboration they offered, notwithstanding the victim's testimony in this case that she had suffered at least some physical injury. The record showed that there was none, granted days later. When she specifically complained of a sexual assault, the medical professionals were specifically on alert to what the allegations were and yet still found no corroboration physically of that. I would also note that there was no expert testimony in this case that would explain why you might not be able to find physical corroboration sometime or days later outside of the acute period of abuse. And so counsel would have understood that she was essentially getting the benefit of the unvarnished findings contained in the records. Inherent in that, obviously, is acknowledging the fact that a complaint was made to medical staff at the hospital. And so I think in that light, the fact that additional complaint evidence came in the records was not prejudicial in this case.
Let me ask you slightly different. Do you agree that if defense counsel had moved, I guess for the judge to make the ruling, that portion of the medical records where it says basically the history that the mother gave to the hospital, do you agree that that would have been excluded?
Yes.
So how do we get around the fact that the judges excluded Mom from testifying to this, and yet it comes rolling in the medical records?
Well, I can see that there was an error for this to come in the first place. Oversight, I think, by both parties. Obviously, trial counsel testified to the oversight, but fair to say, I think the trial prosecutor should have caught that as well. That being said, again, where the defense was essentially implicated that this complaint was made, I think there's less prejudice, and I would rely on Commonwealth versus McCoy for that, where it was multiple complaint evidence came in from the police officer, hospital staff, I think a sane nurse and a parent, and all of that generally inadmissible.
Let me ask you, I haven't read McCoy recently. Were there limiting instructions given in McCoy, first complaint instructions?
There may have been as to the first complaint in that case, but I don't believe as to the multiple.
So that's my problem here. We have, this case to me could, not definitely, but could be analyzed in this way. First complaint testimony was improperly admitted, and the judge failed to give a limiting instruction, as he or she should have. That's what we have here. And there are cases from both our court and the SJC where in those circumstances, improper first complaint and failure to give an instruction, reversible error. How do you distinguish that here?
Well, I think on a couple bases. First and foremost, that it was, again, the cornerstone of the defense to rely on these records. It was not the Commonwealth's argument as to the relevance of what's contained there. And as mentioned, I think the prosecutor made one glancing reference to the records at all in his closing, not to the contents, just saying that they'll be with you.
Prosecutor admitted the medical records, right? It wasn't defense counsel. So you're the proponent.
I believe, no, I believe trial counsel was the proponent in this case.
Defense counsel was?
Yes, that's my recollection, because she sought to benefit from
Okay.
them.
I'm not sure about that. I know she used the medical records
Yes.
to try to her benefit, but I thought it was the prosecutor who admitted them. But I could be.
I may be mistaken. I think that the prosecutor at least lodged some objection to at least one portion of the records. Be that as it may, I would also note that the content of what's reported as the first multiple complaint evidence, it's clear that the mother is simply relating what her daughter told her. She said this, she said this. It's not presented as authoritative, and the notation on the record itself is that it's an alleged sexual assault. So it's
You were going to mention, you got a little bit sidetracked. The prosecutor in closing argument, I think you characterized it as a glancing or brief reference to the records. How specifically did the prosecutor reference?
I believe all he said about the records was that they are, you will have them with you, essentially stating that they are in evidence. I don't believe he made any other comment beyond that. And perhaps that may have been in recognition of the fact that the findings in the records did not corroborate the victim's testimony here. But again, relying on McCoy, I also point out in Commonwealth versus Johnston, there's a case there not with hospital records that were admitted, not as to first complaint issues. There it was post-arrest silence used in furtherance of a criminal responsibility claim. But trial counsel there made the strategic decision to leave references to that in the hospital records unredacted. And notwithstanding the fact that post-arrest silence is a constitutionally sacrosanct area that we, the Commonwealth, cannot seek to benefit from at trial, there the court held that it was a reasonable strategic decision for defense to try to use it in that particular case. So I think Johnston, read in conjunction with McCoy, support that that can be a reasonable decision, and in fact, as the judge found, it was here. To the extent that, again, the multiple complaint evidence indicates that the mother was told, I would also rely on McCaffrey, that based on the circumstances, the fact that the victim here is a 13-year-old girl, the fact that based on Detective Sweeney's testimony from the demeanor at the hospital, the mother was with her, the jury would have understood that this child obviously told her mom. So the fact that the records reflect that, I think, again, in the circumstances, not so unduly prejudicial. If there are no further questions on the records aspect, I'll turn to the first complaint witness. And I think the claim essentially fails on the fact that even as we sit here today, despite the best efforts of appellate counsel, any content of the first complaint witness's testimony remains inherently speculative. Obviously, the prosecutor on the first day of trial voiced some concern that she may try to minimize it, but not that she would contradict it. And I think even that was speculative on the prosecutor's part, and the trial judge did not seem to find that line of argument particularly compelling.
I mean, actually, just drilling down on that for a second, if obviously discovery obligations would have required the prosecutor to relay to the defense any reports about this witness, so well, first of all, I think there's nothing in the discovery that, well, we didn't get the discovery. Is there anything in the discovery that indicates that the Commonwealth spoke to? Because I think your opponent said that the Commonwealth never found her.
Right, correct.
Right. Okay, so, and I guess beyond that, there's no indication that you know of that the Commonwealth spoke to her beyond.
I don't believe.
Okay. So whatever that information is that the prosecutor is relaying, she may minimize, that's coming from hearsay at best.
Or at least perhaps the victim, again, not totally clear, but perhaps from the victim's description of the state of their friendship.
Right. So, or from the victim, I guess, which is technically,
yes.
Whatever, right, from the victim. Sorry, go ahead.
Yep. And again, where this first complaint testimony typically is used to bolster the credibility of a victim in this case, to the extent that defense counsel knew at the time that they're having trouble finding this girl, first complaint typically is going to be harmful to the case. It could show consistencies in the report. She, I think, made a reasonable decision, let sleeping dogs lie. I'm not going to go, search and turn up a potentially and most likely harmful witness who may then, now I know they're looking for me relative to this case. Perhaps now I contact the police, contact the district attorney's office, or at least, know that I should come in for trial. And then
let me ask you about that. And I very personally understand that may be a strategic decision by defense counsel to not seek out certain witnesses. However, doesn't the SJC say that even if a witness is going to be inculpatory, or you expect the witness to be inculpatory, that the defense lawyer has an obligation to investigate those witnesses?
Generally, of course, there's a duty to investigate, but I don't think pursue all ends, particularly if you don't see any fruit there. And in fact,
this wasn't pursue all ends. This was pursue any end.
Sure, but there was a risk to be avoided specifically with revealing a witness that was most likely, again, going to be harmful to the defense.
So do you think on an ineffective standard, that's the end of the story, because we could find, as I think the judge did, that this was a strategic decision made by defense counsel to not investigate that witness, and as we all know, if it's strategic, kind of ends the story unless it's a ridiculous strategic decision?
Typically, and unless it would pursue, leaving some obviously compelling evidence unturned, but that's not the case here. Again, we still have no idea what the witness would have said, and so any, projection either way remains speculative, and I think the case law is clear that that's simply insufficient to warrant relief on an ineffective assistance claim.
I have a question about the CVS video.
Sure.
I note that, and I'm talking about the exterior video. I'm more interested in the exterior video. As I understand it, the video shows that, well, the complainant testifies that the assault stops when the car pulls up next to them, and there's a surveillance video. Well, do we have the surveillance video? I couldn't find it.
I believe it was submitted, or at least I did get a copy on a thumb drive.
I will look at that, and I apologize for not having looked at it. But the picture...
At least part of it's in there.
Okay, great. Defense counsel did show a piece of this, a few seconds is the way it's characterized, a few seconds of the exterior portion of the CVS video to impeach Sue's trial testimony. Is that sufficient to resolve that issue? In other words, it seems like on the face of it, not having watched it, like pretty powerful impeachment evidence. He did this when a car pulled up, and in fact, the surveillance video says, no, there was no car. That's just a lie or wrong or, in any event, impeachment.
Right. So I would say, given her choices as to the various surveillance videos, she reasonably elected the most compelling inconsistency with the victim's testimony, as she testified, and I think as the video from inside CVS will show when the court reviews it. Although she does not appear to be afraid of the defendant at all throughout there, it's still consistent with her testimony that yes, I did ask him to take
Right,
and
sorry.
recite
I'm asking about the exterior. I'm just saying, do you agree, or is it your position that the defense counsel was effective enough on the issue of impeachment with the exterior video by showing the few seconds of exterior video to impeach her testimony?
Yes, I would say yes. I think it clearly made the point because you see the truck leaving the parking lot. So those few seconds do show the circumstances of, according to her testimony, when the car pulled in, the assault stopped, and then that's when we drove away. And what was shown in the video is that that's not exactly what happened.
Okay.
And I see my time is running a little bit low, unless there are any additional questions from the panel.
No, thank you, Counselor. Let me just say one thing to both of you. Please don't rely on the assembly for documents. Please put them in the appendix as well. Our assemblies tend to get put in little miscellaneous, folders, and then we got to go look for them. It's just helpful to have that in the appendix as well.
Absolutely.
But thank you both.
Thank you.
Just a sec. All right, calling the third case, Commonwealth versus Bustard, 24P 1177. I just want to say we can't say the name of the 209A plaintiff on the live stream because of the VACA, so just use something else to refer to her. It's not a problem. It's in the briefs, but we can't put it put it on the internet. All right, whenever you're ready, Counselor.
Thank you. May it please the court, Megan Areste for the defendant appellant, Mr. Bustard. So this case, even before, is really about sufficiency, our main arguments, but even before we discuss whether the messages were properly authenticated, we are arguing that the Commonwealth failed to meet its higher burden of proving beyond a reasonable doubt that the defendant was the person who wrote and sent the Snapchat social media messages that were the basis for this violation, nor that the messages were even sent during the period where the restraining order was active.
Counsel, can I ask you about that?
Yes.
Maybe I missed it. The Commonwealth seems to rely semi-heavily on the emoji.
Yes.
Do we have a picture in the record of what that emoji looked like?
Yes. Exhibit 3 and 4 in the record appendix show the submission. So basically,
Record Appendix 16 is what, this will help Justice D'Angelo. Record Appendix 16.
Okay, so now, isn't that emoji alone distinctive enough that a fact finder using the Lattimore standard could find beyond a reasonable doubt that the emoji there is connected to the defendant?
I would argue absolutely not. So even in cases where you have photographs of a defendant on a social media page, sufficiency isn't found without additional corroborating evidence. Here, you're not even talking about a photograph, you're talking about an emoji. And an emoji is a graphic character that you can create within the social media app based on a limited number of selections. So Snapchat has 900 million users, and maybe they have 10 to 20 different hairstyles they can pick from when they're creating their bit emoji.
Maybe I'm tipping off opposing counsel with this question. Everything you've just said, how the heck do I know that?
Exactly, and we argue, so I was going to get that to my third argument.
I think it ties into sufficiency here. So.
Yeah, I think it does. I mean, I think that the fact finder in this case improperly relied on the victim witness's testimony to how the social media app worked. And I thought a lot about this, obviously, when I was writing my brief, but I thought a lot about it last night. And the Commonwealth cited in their brief to the Gearhart case. And at first, I thought that is so not applicable, because Gearhart is a case where we talk about the layperson can understand the effects of alcohol because it's well known and people have been drinking and feeling the effects.
I'm a little familiar with Gearhart.
Yeah. And then but then the effects of marijuana, not so common. And I would argue, at first I thought, why is that? Why is they referencing that case? But then I thought, you know what, that's really on point for our argument here, in the sense that social media, especially social medias like Snapchat, are very new, are used by a very distinct group of the population, younger people, and are not really...
I take offense to that. I'm very offensive. I'm just kidding.
I don't use it, but my kids do. But I think that the knowledge of the workings, the technical workings of this social media app were beyond the layperson. And I think well within the corners of the transcript, we have the judge saying, you can absolutely assume I know nothing about this. Those are basically his words. And I think that suffices to say that the victim witness being allowed to explain technical workings of how an avatar is created without providing a basis for the fact that you can only select between limited options on an avatar with 900 million users. There's probably 10,000 avatars that look exactly like this one.
How do we know the witness didn't have the knowledge to make that testimony?
I believe that I think that she's definitely established as a user of the technology, but not an expert of the technology.
But how do we know she's not an expert? There's no objections, there's no request for foundation, so we don't really have any idea what her knowledge is.
I think her basis is just that she's a user. I think within the transcript that she's a user of the technology, and this is her interpretation.
Why do you think that?
Because she's just a user of the technology. She's basically saying, my interaction with these messages...
Does she say that? I'm just a user, I don't know anything about how it works beyond as a user?
I think she doesn't say, I don't know anything about how it works, but she says, I saw someone typing, this is how you create an emoji. This emoji is similar to one that he had on another account. And I would argue that her testimony does not illustrate her expertise in any way. And I also think it illustrates that she's almost speculating.
Yeah, I mean, to drill down on this, what's useful to me is there are 3 points here, it seems to me, that you could at least start with. The emoji, which you've covered pretty well.
Yep.
First of all, to put a pin on it, the company creates the emoji, right? In other words, it's a predetermined, or at least the generic features. It's not like you're handwriting or with some Apple pen, a likeness of yourself. You're picking something from that the company created, right?
Yes.
Okay, so that's the first thing. But then there's the screen name, and you can probably swap in different names, but then also the nickname. So in other words, the screen name, the creator of the Snapchat account puts that on, that's going to be, Wood Red Sox fan. And then once that goes out to other people, they're going to get it. They can put their own nickname on it. That's going to be Chauncey. Okay. And so the crucial thing, it seems to me, trying to follow all of this, is to what extent can these various things be changed by the users? And as opposed, that's a crucial question, it seems to me, for the credibility of all these people. And it seemed, I didn't see any evidence so sort of flip over Justice Ditkoff's question, that this complaining witness, she clearly had a bias. I didn't have any evidence that she knew what she was talking about on these crucial questions. How do I know that somebody else didn't have the ability to change this? And am I missing record evidence that she had any evidence that she knew what she was talking about?
No, I would completely agree with everything you said. It is the company's graphics that people are choosing from. There's a limited number of options. They're not using like a facial recognition and making something. It's just things that are chosen. And kind of moving on from the emoji, there's also this idea of a connection, a tenuous at best connection between the names on this account and the defendant. They're asking she is speculating that because his brother's name is Jesse and that he had a family friend whose name was Cunningham, that this account is somehow created and being controlled exclusively by the defendant. You are oceans away from what case law tells us provides that connection. If you look at Purdy, you have the messages are sent from the defendant's computer, the defendant's signature's on it, the defender admits that it's his account and gives his username and password. You have no ownership here. You have nothing tying this account to any device that the defendant owns. You just have speculation that because the defendant has people in his world, two different sets of people that relate to these two names that are being used, that somehow that this is something that's in his control. And even if you were to fully credit that, okay, Jesse is his brother's name, if you look at the case law such as I believe it's the Williams case, where there was a MySpace account in the brother of the defendant's name, the court said not enough because you have an analysis of access. Who is accessing? Is it this other person who's somehow interested who created this account versus the defendant, or who else had access to this technology?
I just want to make sure I'm understanding. I think what you're saying, and I remember this from the brief, but that getting over the question of whether we can reliably say the defendant created this Snapchat account, there's then the secondary question whether we can reliably say that his girlfriend or his brother didn't in fact use his account to send a snap to somebody else. That's the point you're making.
Exactly.
Right.
So I think even if we speculate ourselves to somehow the name Jesse is relevant to connecting this to the defendant, there is the next layer of analysis of access and control, and you have nothing connecting the defendant to having any control over this particular account. And
Am I right that all those people would have had at least some motive to contact her? They all seem to be involved with each other?
Yeah, so when you look at timing, which is really the third piece of evidence the Commonwealth put forward, the first is that somebody's typing a message on a date where she's had an engagement party / birthday party, but again, she's put that all over social media to, depending on how many connections she has over social media, thousands of people could have known. The typing of the message ties back to the technology. Can you really see somebody typing a message? Because no message was sent that day. No screenshot was taken of that typing. So there's that. And then there's the message on the day that the parties, each party's partner had a legal situation regarding a restraining order. So even if you look at that and you try to tie it back to the defendant because of timing, there was other parties that day who were vested in maybe, for example, you could equally speculate that her...
But when we're talking about admissibility,
Yeah.
which is what we're talking about, we're not talking about weight. When we talk about admissibility, do we look at the light most favorable to the Commonwealth?
We do look at the light most
Well, in the
favorable
light
to the
most
Commonwealth.
favorable to the Commonwealth, the timing goes to the Commonwealth. They might have other motives, other people may have had other motives, but we look at it in the light most favorable to the Commonwealth.
But I still think without corroborating circumstantial evidence, you have to conjecture and guess to get to, even with the timing, to get to the defendant being the author-sender. And I think that the argument, obviously, around the timing is stronger when you're looking at the authentication piece and the admissibility of the arguments, but I still think under sufficiency that there's some impermissible guessing to get to that step.
All right, so wait, so just to create some analytical clarity here, it seems like your better argument, the lowest bar you have to reach is the authentication. I think you've been trying to talk to us about sufficiency, and I think Justice D'Angelo is appropriately saying it's an easier argument for you on authentication. So let's spend whatever time we have left, or
Yes.
a little time anyway, on authentication. So what's the standard? Remind us the standard. I'm sure you did in your brief, but what's the standard? And
So authentication, obviously a condition precedent to admissibility. It's a lower standard, preponderance of the evidence standard. But there's an inadequate basis here to even make the threshold determination that these screenshots of these messages were what they purported to be, which is sent by the defendant. Because when you look at digital communications and you look at the case law around it, a judge can rely on confirming circumstances. But we don't have the confirming circumstances here. And what are those? Those are a connection via technology, that this has somehow been attributed to be his account or his password and username to get in, and you don't have any content. So this is a generic message, you happy. There's no substance or case law will say you'll see content that's related to an interaction between the parties, an upcoming court date. They reference a child's name or a pet's name. You have none of that here, content that brings it back to, okay, this is something that the defendant and the victim may.
Well, you had me until you said we have nothing. You do have something. You have, as we've already talked about, a bit emoji that, as we've probably ad nauseum discussed, you have to create that. It's not like you just press a button and boom, it goes up. You have to pick a face, you have to pick a complexion, you have to pick a hairdo. So you've got that. It matches the one that the defendant has used in the past. As far as timing, coincidentally, a message is sent immediately after or even during a hearing that's going on between two parties. So you have a couple of things. I'm not saying it's enough, but when we're talking about authentication, as you just said, you don't have to have much.
I think you have more. If you look at the case law, and there is more case law for authentication than there is for my sufficiency argument, I think you have more than you have here. You have at least a photograph. You have, an account where the parties had communicated with each other prior to the RO being put in place. Here you have an account that the witness testifies she didn't know this account, she hadn't used this account before. If you look at, the Argo case, it's a Facebook account that they had used before. The Armstrong case, it included the defendant's nickname and a tattoo and a picture of his children. If you look at the Gonsalves case, you have an identification that it's his cell phone that the messages are coming from. I think we talked about the bit emoji. It is something, but you have to speculate. With 900 million users, there's probably, I would say, at least 1,000 or more that look exactly similar.
Something you said about 2 minutes ago that confused me. Maybe I just misunderstood, but it was about whether authentication or sufficiency was a stronger argument. It seems to me that if the Commonwealth presented proof beyond a reasonable doubt that it was the defendant who sent the message, then they automatically presented a preponderance. And therefore, if the evidence is sufficient, it's certainly enough for authentic, or it could be authentic without being sufficient. Am I missing something?
Yeah, so I think the standard for the authentication argument it's a lower standard. It's a preponderance of the evidence, and and I would argue we don't have the confirming circumstances, but even we would argue that if this court would find that, okay, the judge had enough basis to authenticate, that that evidence coupled with the additional testimony that came in was insufficient to establish guilt beyond reasonable doubt. Okay. So 2 different standards, but a lot of the same points underneath those arguments.
All right, I think I get it. Thank you, Counselor.
Great, thank you.
All right, we'll hear from the Commonwealth now. Whenever you're ready.
Morning. May it please the court, Karen Palumbo on behalf of the Commonwealth. I'm going to start with the authentication argument. And defense counsel cited many cases that have a lot of factors or a lot of confirming circumstances. We do have sufficient confirming circumstances, although we don't have all of the ones that are contained in those cases. This case is more about timing and contemporaneous events. And the standard is that it's more likely than not that the defendant sent this Snapchat message to the victim in violation of the no contact provision of the restraining order. And the circumstances include that they dated, and during that dating relationship, they communicated via Snapchat. The Snapchat account for the defendant was Jay's World 25, and it had, again, we've talked about it endlessly, but the Bitmoji with the slick back hair and the beard. The victim blocked that account after they broke up, and then she receives a message from Jessamine94.
Are you arguing that that bit emoji is a distinguishing character that it ties to the defendant?
It's a piece of the puzzle, Your Honor. It's not, and the thing is too, she didn't realize who was sending these messages until she got the final message. So it's all of these factors that are continuing. So the unknown Snapchat said, "Miss me." On her birthday, and again, that Snapchat account had the same Bitmoji with the black slick back hair and beard. On her birthday, and again, yes, she did post it on social media, but she has a history of...
Did the first Snapchat she got from this mystery account have the bit emoji?
Yes.
So can't we use that, the fact that she testified that she didn't know it was from the defendant from the first one, even though that bit emoji was there, to say, that's not really distinguishing? Because if she didn't recognize it, why can a fact finder say it connects to the defendant?
Because, again, it's the progression, so it's confirming circumstances. So as this goes on her birthday, they begin typing, and...
Wait, hold on. The birthday was the typing. Miss Me wasn't the birthday, right?
I'm sorry, what?
Miss Me wasn't the birthday, was it?
No. Miss Me was prior to all of this.
Okay.
So Miss Me was the first time that this Snapchat account reached out to the victim. On the birthday, it was the 3 dots. I'm not sure if you're familiar with that. I'm not that tech savvy, and I'm familiar with that. That suggests someone is typing to you.
I want to ask you about that.
Okay,
No message was actually sent.
correct.
So how is that, are you saying that alone is a violation?
No, the restraining order wasn't in
How
effect
can
at
it be
that time.
confirmatory of anything? Nothing was sent.
It's the testimony of the witness that this particular Jessamine94 was sending her a message, although no message was ever received. It's just the fact that he was typing to her.
Sounds like expert testimony to me.
I disagree, and I would just direct the court's attention to Commonwealth v. Knight, which is 100 Mass Appeals Court. I think it's 1130 at 8 through 9. And this court has specifically rejected the claim that the Snapchat application requires technical or specialized testimony. They found that it's within the common knowledge.
Everything about Snapchat, everything about it now just comes rolling in?
Well, Commonwealth v. King states that. I would suggest that the information that was testified to during this trial is pretty limited.
Okay. You don't think it's beyond the ken of a layperson's understanding, the technical stuff that she said about how you use Snapchat, how you can create things, how you can copy things? That's not technical?
Sorry, also, I hate, Knight, I think you're citing Knight, that's unpublished.
I'm sorry, what?
Knight.
Yes, it is.
It's unpublished. It's just helpful to let us know. I mean, you did in
Okay,
your brief.
I apologize.
But reiterate an oral argument that that's an
Okay,
unpublished.
but that's
thing.
exactly what that case said from the appeals court. But in any event, the structure of the Snapchat account is also similar. Jay's World 25 and Jessamine 94. The victim did testify that Jesse is the brother's name and Cunningham is a family friend. But it was when the defendant sent "You Happy," which I would argue is full of content. It's timing and content. This was sent to the victim right after the defendant's girlfriend obtained a restraining order against the victim's boyfriend. And the message was "You Happy." All of a sudden, the victim realizes this is the defendant reaching out to me, and it all makes sense. In following that up, she asked her sister to look up Jessamine 94 on her Snapchat, and when she did so, the name on the account came up as Justin. So,
Can I ask you about the sister, because it sort of ties into authentication and potentially sufficiency? If we find that the judge improperly didn't exclude the sister as a witness, do you think there's enough evidence still?
yes, but I also don't think there is any basis for finding that the judge abused his discretion. He has wide discretion in whether a late disclosed witness should be able to testify. And particularly in this case, the defense counsel had the evidence. They had the screenshot. It wasn't until the morning of trial that the prosecutor spoke with the victim and her sister and realized that the victim did not take this photograph. It was the victim's sister. Defense counsel did not request a continuance, which goes directly to whether there was prejudice or not.
The defense counsel moved to exclude the witness entirely.
Yes, and he did object, but he could have at that point also moved for continuance, and I would suggest that's relevant because it suggests that there was no prejudice. He knew what this evidence was. He's simply questioning a different witness about this evidence. And that's the question, whether the disclosure was sufficiently timely to allow the defendant to make use of the evidence. And he had that evidence to make use of it prior to trial. So I would suggest that the judge did not abuse his discretion in allowing her to testify. I'd send the court's attention to Commonwealth v. Kerrigan. Again, I think it's an unpublished, Your Honor, but it's 91 Mass Appeals Court at 8, where the defendant objected but did not request a continuance. And then in Commonwealth v. Scally, 17 Mass Appeals Court at 231, there was no error because the prosecutor disclosed on the first day that he gained knowledge of the witness. And that's exactly what happened in this particular case as well.
So can we, I'm sorry, I'm still not, it's clear in my mind at all on authentication. And I've got a lot of ideas swirling around my head, and I'm looking for analytical clarity. You have these witnesses, these lay people with all sorts of crazy motives testifying about this technology and what they can tell about it. And I think in the authentication context, we're supposed to essentially resolve all credibility determinations in their favor. I think, the Commonwealth's favor in this case. But on top of that is a level of technological competence. There is no, for authentication, yes, preponderance, but how are we supposed to look at whether what they're saying is technologically even possible, never mind accurate? And you say that this unpublished case, Knight, says that lay people can tell us everything. But that seems crazy.
It doesn't say that, it says that it's within the common knowledge of jurors.
Okay, it's clearly not within the, back up. Let's just assume it's not, let's assume that this panel disagrees with that. Let's assume that some of this stuff is not within the common knowledge of jurors. On authentication, ensuring, all of this comes down to one simple word, reliability. How can we know, the gatekeeper, the judge, has to make an authentication determination about reliability before the judge, as fact finder, decides to consider this stuff? And I'm deeply troubled by the notion that this was reliable evidence. Why was this reliable?
Well, it comes down to the credibility of the witness testifying, and the judge at the trial is in the best position to observe the witness testify. And he accepted her testimony.
What if she's telling the truth to the best of her ability, but she doesn't know what she's talking about because it's technologically beyond her abilities?
Again, I'm just...
Is that an error by the judge?
No, I would say not. But I'm going to say again, even in Purdy, and it says that neither case law nor our rules of evidence have required expert testimony to authenticate digital communications. And I would suggest that's still the law. Unless this court decides it isn't. But
I don't think we're, all right, you've made a good argument. That's an excellent argument.
In any event, with respect to the motion for the required finding, circumstantial evidence of guilt and reasonable inferences therefrom are sufficient. and the evidence is viewed in the light most favorable to the Commonwealth. And I would suggest the evidence in this case, when it was viewed in the light most favorable to the Commonwealth, was sufficient to establish that it was, in fact, the defendant who sent the message.
Let's say we find, this panel says, the gatekeeper was right. It just barely gets over the preponderance of the evidence standard. Does that end the story?
It
Or is
doesn't.
sufficiency still an issue?
It is still an issue.
So how do we do that? We say that by a preponderance of the evidence, in a light most favorable to the Commonwealth, we find that the defendant was the one who authored these
Right,
things.
right.
We now have to flip the switch and say, now, in a light most favorable to the Commonwealth, is there enough beyond a reasonable doubt? Isn't that sort of the same thing?
It is sort of the same thing.
Is that right, legally?
Well, no.
So we
it-
say,
no,
we
no,
come
no.
up, we come out and say, there's just barely enough.
So I think what's a little
Preponderance.
tricky here, so yes, the judge admits it. In a jury trial, then it would be up to the jury to define whether it be under reasonable doubt they believe that the defendant authored it. And because we do not have a jury, it was the judge who made both determinations. So ultimately, when he denied the motion for required finding of not guilty, he determined that there was sufficient evidence beyond a reasonable doubt that the defendant was the author of the Snapchat message.
So you agree that we could find that by a preponderance, there was enough,
Yes.
but we disagree that even in a light most favorable to the Commonwealth, there wasn't enough for beyond a reasonable doubt. We could do that.
You could. I don't agree with that, but you could do that.
Okay.
There are two different sets of, or bars to clear. And I would suggest that in this case, both of those bars were cleared. And I would ask the court to affirm the defendant's conviction for violation of a restraining order. Thank you.
Thank you, counselors. I think this is a pretty interesting case, and we'll take it under advisement.
I can-
We'll hear one more case, and then we'll take our break. The next case is Lester versus Old Republic Title Insurance Company, number 24P 1027. Whenever you're ready, Counselor.
Thank you. Good morning, and may it please the court. My name is John Postel. I represent the plaintiffs, appellants, Douglas Scott Lester, John Tyler Mandeville. I'll be referring to them as the insureds, as I did in my brief. I think that the place to start here is whether or not the property at issue was insured premises. So, as you know, this case involves the location of a stone wall.
Can I stop you? Because I don't think that's where we begin. Don't we begin with the premise that the policy is a contract? It's
Yes.
a contract between the two parties.
Yes.
There has to be, going back to all of our days in law school, there has to be a meeting of the minds, correct?
Correct.
And that has to be put into terms in the contract.
Correct.
How in the world could there be a meeting of the minds of what that policy covered as far as the land when no one who formed that contract knew about the derelict fee statute, that it could, they may have known about the statute, but they didn't know that the land was going to be expanded to what was in that contract? How is there a meeting of the minds there?
Well, I would argue that Old Republic knew or should have known that the derelict fee statute would cover this land, and that if they wanted to exclude it, they should have done so explicitly. The insureds, I don't know that the insureds would have that sort of knowledge. It's a very sort of arcane thing. I didn't even know about the derelict fee statute until I got this case. And so...
But there's no meeting of the minds there.
But there's a...
Even if, and I'm not saying I agree with you, even if the title policy people knew that that land should be covered, the owners didn't. So they're not meeting minds, are they?
The meeting of the minds would be, I think, do the did the insureds have a reasonable expectation that land that they bought and that they owned in fee simple would be covered by their title insurance company? And I know I cited the Murray case, which was a California case, which said that an insured would expect that if they have land and they own it in fee simple, that the coverage of their title insurance would be coextensive with the land that they own in fee simple. And so if Old Republic didn't want that result, which we argue that the derelict fee statute mandates, that they should have excluded that specifically.
Can I ask a different starting point? My starting point is I'm driving down this road, or I guess we're calling it a private lane, and I wish I'd had some pictures. I had some satellite photos, but I'm driving down this lane, and I look to your client's property. I think on the pavement, which is 10 to 12 feet, I'm on the pavement of 10 to 12 feet. I turn, I look, there's grass, there's a stone wall, there's more lawn, maybe trees, and then a house eventually, right? It's the front yard,
Yes.
right? Is there any way to know about this mythical 40-foot wide way? When I'm driving down, is there any demarcation physically, landmarks of where this alleged 40-foot way existed?
There's not.
Okay,
Justice
so
Wood,
what I wanted, so my big, if your clients thought that this 40, I'm thinking, they fixed up this stone wall because they thought it's on our property. We don't know about the derelict fee statute. We haven't read our deed. We don't know what meets and bounds mean. We just think that you can infer clearly that we thought this stone wall was on our property. Is that, am I
That's
with
correct.
it so far?
No, that's correct.
Okay, all right, but they're going to say, yes, but your clients should have read their deed. They should know that on the deed it explicitly says your property ends at the northern edge of this mythical 40-foot way, right? That's what they're going to say.
Yes.
Okay, so what's wrong with that?
A couple of things. One is that when you read the derelict fee statute and the actual language of the statute, it says when you in essence, when you read deed language, any property that abuts away, when you're reading a deed to a property that abuts away, the deed is construed so as to include the property to the midway of the way in fee simple. So where the policy in the description of insured premises in the policy, it's the deed description. Old Republic admits that.
When you say the deed description, what do you mean?
So
it doesn't say as described in the deed. It's not what it says.
So the deed, no, and so the deed, a deed has a meets and bounds description with, you know, the latitude and the longitude and the northwesterly and running southerly by this
one
many
has
feet.
a specific reference. This deed says it's Hillcrest Acres Lane, so-called private way, minimum 40 feet wide. That's in the deed, right?
Yes.
That's the southern boundary of your client's property according to the deed, right?
Yes.
Okay.
And so the deed, that deed language, Old Republic, when it issued the policy, it picked up the meets and bounds and put it into the policy in the description of insured premises.
Right, so the statute says that an instrument passing title to real estate will be construed to add some stuff. It doesn't say a description of land in a title insurance policy shall be construed as adding stuff. So what am I missing?
Well, it's that they use that language.
What language?
So if they took they took the language from the instrument that passed title, had this meets and bounds description.
The deed.
And Old Republic took that language and put it into the definition of insured premises in the policy. And so the argument would be that because they used that language as opposed to some other way to describe what the insured premises is, that because they're tracking the deed language, that would implicate the derelict fee statute. So when you're reading that language, you read it so as to include the land to the middle of the way in fee simple. And so, you know, we would argue that the case law in Massachusetts, and back to Justice D'Angelo's question about meeting of the minds, is that the case law says that if there are two possible interpretations, one is, does this language in the definition of insured premises in the policy pick up the additional land by virtue of the derelict fee statute, or does it not? That the law says you adopt the interpretation that's most favorable to the insured, which would be...
Can I make sure we're on the same wavelength?
That it does, yes.
The language that's in the policy, the title insurance policy, tracks the language that's in the deed, correct? Okay. So, sort of back to what I started with. Isn't that in and of itself an exemption to this extra piece of land? We are covering this. And when I say this, what's in the deed? We are not covering anything else. There's no need for an exemption. What an exemption would mean is we are covering everything in this, the deed, except for blah, blah. That would be an exemption that would have to be specified in the policy. Here, it's the exact opposite. We are covering this, i.e. what's in the deed, and nothing else. And you now are saying, because of the derelict fee statute, their land, which is not included in the deed, is also this. That's exempted from the policy, isn't it? Because they're saying we're only covering what's in the deed.
They're saying that they're only covering what's in the deed, but the argument is because they're using that deed language, that when you're reading that language, that because it's the language from the deed, that implicates the derelict fee statute, so you need to include the additional land.
It might implicate it, but it's not stated in the deed. And in a contract, it's only what's stated in the contract, i.e. the policy, that's covered, isn't it, under the law? But the statute is telling you how to read that language. So if the statute says...
the statute's telling us how to read instruments passing title to real estate, right?
Correct.
It's not telling us how to read anything else, is it?
But the language, the argument is that if that language is the deed language, and the point of the derelict fee statute is that the legislature is saying that this is property that you get in fee simple when you have property that abuts away. And so by picking up the language of the deed and not identifying insured premises, they could have done it any other way. They could have said it's 47 Hillcrest Acres Lane. They could have said, the deed description. They could have exempted the derelict fee statute.
I think it'd be much better off if they had said the address. I think most people would consider the address to include your stone wall. But instead they give meets and bounds.
They actually do, in the policy, it does reference the property address as well.
Are you arguing that if they had put in an exemption, we are only covering the language included in the deed, then it would have been okay? I'm trying to figure out how a title insurance company protects itself from potentially the derelict fee statute or something else where somebody later on acquires more property that nobody knew about at the time of the title policy. So what should they have written?
And maybe after this, Old Republic will say any property that the insureds own in fee simple pursuant to the derelict fee statute is not part of the insured premises. Just like they have, we're talking about exclusion number 8. There I don't know in the policy how many enumerated exclusions there are. So they certainly know how to exclude the things that they don't want to cover. And our argument is that this was not one of them.
Can I sort of shift to a somewhat separate issue? If we decide that the fee interest under Hillcrest was not covered by the policy, do any of the 93A or 176D claims stay in the case?
I would argue that they do.
How?
Because you've got a situation, one of the things that I argued in the motion for reconsideration under the 940 CMR that provides, mandates somebody dealing with a Massachusetts consumer to disclose in a transaction all information that is deemed relevant material into entering into that transaction.
Is there any evidence in the record that the title insurance company knew or should have known that the derelict fee statute would include this extra piece of property at the time they made the policy?
Yes.
What is there?
So, and I would answer that in two ways. And one is that under my argument under 940 CMR was that there's an affidavit from Mr. Lester saying, well, if we had known that this wasn't covered, we could have gotten it. My sister at oral argument in summary judgment in front of Judge Cowan said, well, if they wanted to get this coverage, they could have gone somewhere else and they could have gone out and bought it. So there's a question about whether or not, and there may be a question of fact to reverse to say, is that something that Old Republic should have disclosed? And was it reasonable
But the
for them?
question was, how does Old Republic know? The fact that Lesters don't know doesn't prove Old Republic knows.
Well, Old Republic did know, to get back to the second part of your question, Justice D'Angelo, was they did know because after Judge Yasayan, and again, remember, when the Dromskys originally sued my clients, they went to Old Republic and they said, we want a defense. They came up with 3 reasons saying, no, you can't have a defense. And then the case went forward, and when Judge Yasayan issued his summary judgment decision in which he found there is no 40-foot right of way, and he found that the Dromskys didn't have an argument because the land under the stone wall was owned by the insureds in fee simple pursuant to the derelict fee statute, then the insureds went back to Old Republic and said, hey, look, here's Judge Yasayan just issued this decision. This is what he found. Now you need to come in and provide a defense. And they went back and they said, no, his decision doesn't mean anything.
So there's no evidence that at the time the title insurance policy was written, they knew. You're saying they learned about it later on, and once they learned about it, then their obligation to defend comes in.
At a minimum, it should have come in then. So we argue that they should have done it at the beginning. Their grounds for denial in the beginning we found were baseless, and so I think that's where we are. And I see my time is up. Unless you have any other questions, I will rest on my briefs.
Thank you.
Thank you, Counselor. We'll hear from the insurance company now. Whenever you're ready, Counselor.
Good morning, Justices. May it please the Court. My name is Shannon Slaughter. I represent Old Republic National Title Insurance Company. I think Your Honors are correct in that where we start in this case is the policy itself and the express terms of the policy.
Okay, so on that, the deed, which is used as, is cut and pasted into the policy. Let's say I think that's legally significant. You're cutting and pasting the deed description of the property into the title policy. That what you use is Hillcrest Acres Lane. So it's not the normal meets and bounds of longitude and latitude. It's this description of this thing, Hillcrest Acres Lane. Now, in reality, Hillcrest Acres Lane is a road. It physically is 10 to 12 feet, and it's below that stone wall that we all care about so much. You guys wanted to use some mythical, different definition of Hillcrest Lane. So it all comes down to these 3 words that got stuck in there, 40 feet wide. So in other words, if that 40 feet wide is stricken, then suddenly the property is on the property, the stone wall is on the property as described in the deed and in the title insurance policy. So it seems to me deeply problematic that these customers of yours would have to know that the Hillcrest Acres Lane that you're talking about, that whoever put this in the deed 50, 60, 70, 80 years ago is not the Hillcrest Acres Lane that they see and drive on every day. It's some other thing which actually doesn't exist. That's fair? Why is that fair?
Well, Your Honors, what we're looking at is not what is described in the deed, right? Although the meets and bounds language is the same as what is described in the deed, there is a reason for taking that meets and bounds language and putting it into Exhibit A. In the
right, to let them know what their property, what property is insured, right?
Correct, Your Honor.
And it uses a physical thing, the road. But you're saying, yeah, but it's not the road, is it? It's farther north of the road, on the other side of that stone wall.
Well, the 10 to 12 foot lane that was decided by the Superior Court after the claim was filed, that is part of the 40 feet. So it's a part of what you're talking about.
It's smaller than 40
feet. Smaller than.
But the 40 feet thing, you're implying in your statement, that is an actual thing. There really was a Hillcrest Acres way that is 40 feet wide. And the court is actually saying, no, there's not. There never was.
Right, but what the policy is saying, regardless of what the deed says, regardless of what the fee interest is that the owners have in this Hillcrest Acres Lane, the 40-foot wide area, regardless of what they may own in it, what is being insured here is shown on this 1985 plan, the 40 feet wide.
Which was never adopted, right?
Which was never adopted.
It's just something that some people created.
But it is shown, it is physically shown on a plan referred to in here, Hillcrest Acres Lane, this 40 feet wide. It is exactly where, there's a plan that shows exactly where this 40-foot wide area is adjacent to Lot 13 on that plan. And if that isn't, Your Honors, I submit that it is enough, the way that the meets and bounds description reads in the title policy to exclude Hillcrest Acres from the insured property. But if that's not enough, there is a belt and suspenders in this policy. If you go to exclusion number 8, it's Record Appendix 4, page 121, exclusion 8 specifically states that in addition to the exclusions, you are not insured against loss, costs, attorney's fees, and expenses resulting from, you go down to exclusion 8, Title II and rights of the public and others entitled thereto, and to those portions of the insured premises lying within the bounds of Hillcrest Acres Lanes and the adjoining streets.
Now you lost me, and you had me before, because this doesn't say Hillcrest Acres Lane as set forth in this plan. It just says Hillcrest Acres Lane. Why wouldn't an ordinary insured think that means the actual physical road that says Hillcrest Acres Lane on it, and not what's shown in the plan that doesn't exist as an actual road?
Because of how it's described in the meets and bounds description, Your Honor.
No, I get the Exhibit A thing,
Right.
but I don't get the exclusion, how exclusion 8 helps you if A doesn't get you there. Or do you mean the combination of the two explains it?
The exclusion 8 is a belt and suspender. So Justice D'Angelo asked the question, how does a title insurance protect itself from insuring against the derelict fee statute? Well, this is it.
You're saying
Exclusion
construe 8 in light of A. Is that what you're saying?
Exclusion 8.
Interpret 8 in light of A.
In light of A, yes.
But so how do you protect yourselves? Great question. Yeah. So why, we went back, there's a whole bunch of questions for your opposing counsel about what you guys would know. Did Old Republic know about the derelict fee statute at the time?
I mean, I don't think there's any evidence in there, but it's
okay, so let's say there's no evidence. When you're dealing with a criminal defendant, the criminal defendant is assigned knowledge of the law. We say it's a black letter principle. Ignorance of the law is no excuse. Mm-hmm. And there's all sorts of good reasons for that. Now here, we're not talking about a criminal defendant, a layperson. We're talking about a highly sophisticated title insurance company.
Yes.
I'm supposed to believe that, first of all, doesn't matter, but second of all, that Old Republic didn't know about the derelict fee statute?
But that's not what we are arguing at all.
Okay, but right, so it's fair to assume, well, A, ignorance of the law is no excuse, but B, Old Republic actually knew about the derelict fee statute here. And so what it means in concrete, realistic terms, maybe not concrete, stone terms, is that Old Republic knew full well there's a property here. It stops short of the road, and then there's this gap, and you're going to own all of it, but we're only going to insure up to the point of the northern edge of this mythical way. To me, that's misleading.
Well, Your Honor, I think that's the reason why you have a meets and bounds description that has, calls and distances that say exactly what is being insured. And it's not Old Republic's responsibility to go out there on the ground and delineate or stake out the exact area that is being insured. Old Republic doesn't know what portion of Hillcrest Acres Lane is paved when it issues a policy. All it knows is what it is describing in a meets and bounds description, in the exclusions that are set forth in, I believe it's Schedule B, and that is how the title insurance company protects itself. There's no argument being made at all that the title insurance company did not know about the derelict fee statute.
So why wouldn't it be good policy, and I realize this is getting into touchy ground, but let's say there's no precedent here in Massachusetts to address this question so we can take a crack at it. Sure. Let's say we like the California case and their reasoning, which was clearly founded in public policy, where there's a party here with greater knowledge why isn't it okay to say that the rule should be, that party with greater knowledge, you don't really need to protect yourselves that much. In this specific context, it's a really small little thing we're talking about. Your property, which is defined by the contract, by the words, as this mythical line, is going to include the other property that we, the insurance company, know full well you own, all the way to the actual physical road. Why don't we say, as a matter of public policy, Old Republic, you know about the derelict fee statute. You're smart. You're knowledgeable in this area. We're going to require, as a matter of public policy, because your clients don't know it. We're sure they don't know it because they fixed the wall. If they hadn't thought that it was their property, because it was their property, that you are obligated to cover any crazy claims that come up over that strip of land. Why isn't that a good idea as a matter of public policy? Better for everybody.
Well, Your Honor, if you do look at the Murray case, they were talking about 4 separate scenarios, and that ultimately fell in the 4th scenario. And even the Murray case said that if there was a meets and bounds description in that deed, then the policy, they would have held that the policy did not cover the rights in the road. Where there's a vague description of just a lot on a plan, or, for example, I don't know, had it just referred to the deed itself, and the deed itself contained a catch-all clause that said, and all rights are pertinent thereto, which many deeds do, then perhaps it would be a different situation. But that's not what we have here because of the very specific meets, bounds, distances description. Although it's the same as the deed, it is not the deed itself.
I'm sorry, I'm confused because you keep saying meets and bounds description.
Yes.
And to me, that's longitude and latitude, a series of 3 numbers and maybe a degree. But here, we don't have that. We have words, plain old words, and those words are Hillcrest Acres Lane, so-called private way, min 40 feet wide.
Well, then it describes it as follows, and
Right.
it gives the longitude and latitude. So the first part might be a little confusing because it's a lane that doesn't really exist, but then it gives the blueprint. Right?
Correct. That's what I'm referring. When I say meets and bounds, I'm referring to where it
I
follows.
get it, but I feel like, well, okay, I'm going to stick with this for a second.
Okay.
Accepting that if they went out and hired their own surveyor to figure out where that line is that's created by the meets and bounds, they would understand that it's north of their stone wall. But since you've given them something that's in plain old English, and it seems simple, let's imagine a world where people read their deeds, where people actually know the meets and bounds of their property because they walk it for some reason.
I have done that.
Let's assume that we did do that. Here, they would actually think, oh, it goes to the edge of the road. Is it not misleading? I'm still thinking it's misleading that they're given these 2 ways to know it.
Your Honor, I don't think it's misleading because of how very specific these meets and bounds descriptions are, because of exclusion 8, because that was the belt and suspenders, to the extent that somebody doesn't know exactly where these meets and bounds description are. Well, it was made very clear in exclusion 8 that this Hillcrest Acres Lane that's shown on this 1985 plan, that's 40 feet wide.
You know what I'm going to say. You snuck it in there. That's this 1985 plan that's shown very clear. Hillcrest Acres Lane is an actual thing. It actually is there. Exclusion 8 makes reference to Hillcrest Acres Lane, which is a 10 to 12 foot wide road, which is crucially below the spot where the stone wall was fixed.
Well, I think that's a very important distinction, Your Honor, that's kind of been point of contention in this case. How the terminology that is used, right? Because Hillcrest Acres Lane, as used in the policy here, is 40 feet wide. Hillcrest Acres on the 1985 plan is not Hillcrest Acres Lane, it is Hillcrest Acres. Hillcrest Acres Lane, the lane as described in the Superior Court's Dromsky decision, is the 10 to 12 foot wide paved area. But the Dromsky decision court also held that the private way, the 40-foot private way, was the way. So the way itself exists as shown on this plan. Hillcrest Acres Lane, the private way 40 feet wide, as defined in the policy, that is the Hillcrest Acres Lane that we are talking about in this policy, regardless of whatever is held by the Superior Court in the Dromsky action, regardless of what is shown on the 1985 plan, it is defined in this policy as this 40-foot wide.
It may actually cover more, or it may actually cover less. It doesn't matter because that's what's in the 4 corners of the document.
Of the policy.
Of the policy.
Exclusion 8, can you quote me Exclusion 8, the Hillcrest Acres, finish the Hillcrest Acres blank?
In exclusion 8. Hillcrest Acres Lane.
Right.
Which is
not Hillcrest Acres Way.
No, but which is defined in the policy as the 40-foot wide.
I get it. But if you actually read, if you just read exclusion 8 and you read the words Hillcrest Acres Lane, you wouldn't, the problem is you're not understanding that Hillcrest Acres Lane is defined somewhere else as actually Hillcrest Acres Way, which is 40 feet wide.
But they're both part of the same policy, Your Honor, so
Right,
you do
right.
know that if you read the whole
Right.
contract as a whole.
Right, someplace else is what I mean. Yeah, I got it. Okay,
Correct, Your Honor.
all right.
If there are no further questions, I'll rest on my briefs. Thank you.
Thank you both. We will take our break now. It will be no more than 15 minutes.
I've always liked it. No. And Chuck. Yeah. I think he's just doing one little part. Yeah, that sucks. I was like, who am I going to ask questions? I like it. Perfect weather for a guy like me. Oh, she's my associate, so, but yeah, give her the thing.
Sorry to go a bit over. Court's back in session. We'll hear the fifth case, number 25P114, adoption of child. Before you start, let me just remind everyone that we're not going to name the child or the mother. We're not going to use initials. We're just going to say child, mother, and that's how we'll do it. Whenever you're ready, counsel.
Good morning, Your Honors. Richard Shokire for the appellant mother, who has been in the courtroom all morning. She must have stepped out. May it please the court. Mother asked this court to vacate the orders and decrees terminating her parental rights to her child, remand this matter for further proceedings. The evidence in this case does not support the lower court's determination of her unfitness. Rather, it sort of underscores the court's and the department's sort of predestination of a woman who has struggled with mental health issues, which she acknowledges, and who, like so many others similarly situated in these cases, find themselves involved with the department, the police, or any number of state agencies, trying to navigate this labyrinth of services and therapies and visits and housing. She's not asking this court to solve these sort of intractable social issues. Instead, what she's asking this court to do is to look contextually at the evidence, which demonstrates that she substantially complied with her services in this case. Her collaterals and reports show that she was never a danger to herself or to the child. This is even taken from the department's own evaluation, which she submitted to, which made a determination that they couldn't find how her mental health was related to her parenting, and which tellingly did not require her or suggest that she needed to take medications.
Counsel, can I ask you sort of just a preliminary
Certainly.
question? Are there any specific findings of fact that the judge made that you find erroneous?
Your Honor, I did see that through my sister's briefs, but I believe that rather than the erroneous nature of it, like for instance, I believe one of the findings was about mother coming to a birthday party or something like that and walking off with the kid. These are reports from 51As that this court can sort of this wasn't trial testimony where the judge is observing these things.
We can disregard 51As, right?
You can.
Right.
You can. They primarily set the stages for these cases. If I can continue, there's...
Could I?
Certainly.
I just want to say, first of all, I think your client did remarkable work, very specifically in maintaining relationship with her child. And the record speaks very clearly about continuing to show up for visits with the child right up until August of 24, the
Yes.
month of the trial. And I want to be clear about that. But the problem I see here on the question of fitness and termination, the single biggest problem, and also, no evidence, I heard what you said, no evidence of ever harming the child.
Yes.
And absolutely. But the problem I see is refusing, and one more comment, that she continued to maintain a relationship with a therapist. Also a good thing, I think, supported by the record. But refusing medication when medication had been shown to maintain stability. How do you address the risk of future harm or neglect based on the long-term refusal to accept medication?
Your Honor, I think it speaks to my brief. This is very analogous with the case that I cited, care and protection of Bruce. In that case, the mother also refused to take her psychotropic medication. In this case, it's risperidone. But what we have in evidence is that it wasn't necessary for mother to function. She was simply more organized. It wasn't she was some threat to herself or to others. As where, if I can draw a distinction between this and Bruce, Bruce had substantive evidence. There was testimony by the mother's psychologist and psychiatrist who both opined that if she were to not take her psychotropic medication, she would be a harm to herself and to the child. There's really no evidence that speaks directly to that in this case. The prognostic evidence seems to be drawn from a nebulous of evidence that I believe was most recent in 2012 or 2013. And I believe that if we apply RONA to that,
But counsel, again, we can look at the past. The courts have said we can look at the past for future harm. By not taking her medication, and I'm looking at findings of fact, which you don't dispute, she was hospitalized 5 times, partly because of refusing to take medication and her mental illness. Doesn't that go to, if she continues to not take her medication, it's reasonable that she's going to be hospitalized again?
Your Honor, I think that there is a reading into that. There is no evidence that necessarily, if she did not take her medication, she would be hospitalized. I think she had a series of hospitalizations and then was not hospitalized from the time of the filing of the care and protection, at which time the department insisted that she go in and have a psychological evaluation. She never met that criteria. And for over 3 years, there was no other hospitalization as far as I can remember in the record.
2000, you're correct, 2021.
2021, and that was, I believe that was at the request of the department, and nothing came of it, much like the initial 51A that found that the child was not substance exposed, that mother was actually doing quite well with the child, that she had a car seat for the child at dismissal, and that they couldn't, I believe at that point the hospital had actually determined that she didn't qualify for a psychological evaluation because there was no behaviors that would indicate anything like that.
Right, but I mean, there are other episodes. The one I'm thinking of, but there are several of them, that she's had a long string of 8 hours a week of visits at the pre-adoptive, at her aunt's home with the child, and it's going well. It's been really going well. It's been expanded to 8 hours a week, and the DCF caseworker has decided I don't need to be there anytime. It's clearly going well. And then one night, she shows up, according to the aunt, in the rain, demanding to see the child, and the aunt calls the police, and she doesn't harm anyone. She's standing out in the rain, but the picture that's created is one that's upsetting. And you're thinking to yourself, if this why did this happen, and if this happens, in the future, and is that caused by mental illness?
Again, there's nothing that directly shows, I mean, of course, we can all draw our conclusions from, the judge was, had the ability to do that, but I believe what we're actually arguing here is whether or not these instances rise to the level of grievous shortcomings that would place the child at an imminent risk of harm or neglect, and I don't believe that is present here at all. If I may continue, if the child lived with mother for more than 2 months when DCF showed up demanding that she have a psychological evaluation, and they had a Gordian knot that they presented to her of, we're either going to remove the child or you're going to go to the hospital. Well, she went to the hospital and they removed the child anyway. And from that point on, which I believe was in the preface of Care and Protection of Bruce, there was really no effort to sort of allow her to parent the child by herself.
2 months? I thought it was just 1 month. June, 5 weeks.
5 weeks.
All right.
Oh, I'm sorry. Did I say, I'm sorry. 5 weeks.
I apologize.
Right. Yes. I apologize. So with that said, I believe that the facts and circumstances in this case are completely analogous to Bruce. And in fact, as I stated earlier, there was far more evidence, far more substantive evidence with respect to the trial that took place in Bruce than there was present here. The judge placed significant emphasis on the psychotropic medications, but
I think rightfully so, counsel. I'm not protecting the judge, but minimizing it I don't think is your best argument here. The problem here is, at least the way I see it, the judge finds that she lacks insight into her mental health diagnosis. She doesn't adequately address the mental health by taking medication, and she lacks any insight into how her mental health plays into parenting. That, to me, is the most important crux of this. If a parent doesn't recognize the mental health and how that affects her parenting, isn't that a problem for future harm? How do we ignore that?
We don't ignore that, but I believe that the evidence speaks to mother's acknowledgement and addressing of this issue.
But the judge doesn't credit that, counsel. And that's why I asked you at the beginning if there's any findings of fact you dispute. Every time that she talks about her mental health and that she understands, that she acknowledges, the judge doesn't credit that. And we're bound to, we have to accept that.
But, Your Honor, under Surge, the judge has to credit positive evidence, which was abundant in this case. Mother complied with her services. February 22, she submitted to the DCF's mental health consult. They couldn't identify how her mental health issues affected her parenting. They did not recommend any medications. The only recommendation was that she apply for voluntary services through DMH, which she did with the help of her parent mentor, who was only contracted to work with her until September of that same year. After that, the department simply didn't follow up with it. She admits that she struggles with mental health. She acknowledges this. She participated with her parent partner, and I believe in April 22, the department determined that she did qualify for ADA services, and I realize that that's a waived argument at this point, but the department never really scheduled an ADA meeting. There's no evidence that shows that they actually actively worked to make that happen.
Not too much time. I have a specific question which may or may not also involve a waived argument. Assume that we move past unfitness and termination to continued visitation. I noticed something that struck me, and I know your position is they failed to prove sufficient evidence for termination. But the judge also said, no, I leave future visits up to the pre-adoptive parents in their best interest, in their best judgment. And I know that it's possible for a judge to order some future visits, at least for some period of time. And the test is the best interest of the child. I noticed that the judge didn't make any findings about why there should be no future visits, and B, you didn't make an argument about this. Now, I think that's because you're arguing that they didn't satisfy termination, so I don't reach that.
That's correct.
Right, okay. And so if we could get around a waiver problem there, could you speak to that issue of future visits and for the value of the child?
If I could make the alternative argument that
Sure.
even if she were fit, which I do not concede, that it would not be in the child's best interest to not be around mother. I believe there's first of all, the pre-adoptive resource is mother's aunt, and who was a former DCF social worker. And mother has what I believe to be a good bond with the child. The only visits that she missed, though the court didn't credit this, were I believe for 6 weeks or 6 visits where
right, we can move past that. I agree with you that she was remarkable in her sticking to the plan compared to other cases which are irrelevant. She stuck with it. She kept coming back, right, in spite of homelessness. She kept coming back to see her child. That struck me. Go ahead.
Moreover, she made active efforts to engage with this child. She brought coloring books, they danced, and a lot of what I would suggest to this court, the department's sort of observations of the child not engaging is that the child was diagnosed with autism, I believe, in August of 24, and that, you know, as a parent who deals with that myself, I believe it's characterized by, you know, inhibitions and inabilities to socialize and engage with people. I don't believe it would be in the child's best interest to have no contact with mother, but I do understand that that was sort of waived at trial, and that.
Okay. Thank you. Thank you for that answer.
Okay. So the facts and circumstances of this case don't rise to the evidentiary or analytical threshold that we find in Bruce. It simply doesn't support the judge's determinations, and therefore mother requests that this court vacate the decrees and orders and remand this case for further review.
Thank you, Counselor.
Thank you. If nothing more, I would rest on my brief. Thank you.
We'll hear from the department now.
Good afternoon. May it please the court, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the decree terminating mother's parental rights because taken together, the findings clearly and convincingly demonstrated her ongoing unfitness to parent this child. The judge had the benefit of being able to observe mother's demeanor in the courtroom and could note that there were several occasions, and the judge made a few findings when she was asked about her her struggles with her mental health, how her mental health could be improved, what type of safety plan she would be able to implement, were she to encounter a further mental health episode. For each of those questions, mother was non-responsive. So I just kind of would like to highlight that because I believe my brother suggested that mother was a little bit more open in her testimony about the mental health issues. The judge also clearly linked, as I believe Justice D'Angelo noted, the benefits that mother obtained from adhering to a medication. When she was prescribed medication, the department observed her to be able to have conversations about her mental health, and that when she ceased that medication, not only did she become, more escalated and confrontational with the department, but also there was an impact on her visits with the child that she was a little bit more, less interactive with him. So taken together, this information demonstrated to the judge that where the parent had no insight into the mental health issues and how they impacted her parenting, it was sufficient and appropriate to terminate her parental rights.
In that type of circumstance, do we need to find a connection to this specific child in mom's interactions. If, as the judge made, I think, abundantly clear, there's non-compliance with medication. When there's non-compliance with medication, she has severe episodes at times. But, as opposing counsel points out, as related to this individual child, and it was a limited time, nothing really affected the parenting with that. Can we ignore that and just look at the non-compliance and what that could do in the future based on her past?
Well, I mean, the judge is not bound, and this panel is not bound to wait for disaster to strike. And so where there has been a pattern of stability in connection with medication compliance, perhaps, during these supervised visits where mom was taking medicine and nothing occurred detrimental to the child, the abundant evidence of instability when not on medication is persuasive. We don't need an incident to occur to look into the future and find that it would not be safe and appropriate.
I guess what I'm trying to figure out here is, and I don't think there's a lot of case law in this aspect, how many hospitalizations sort of does it take for a person to have when you say, if she's non-compliant, she's going to keep being hospitalized for 3, 5, 7, however many days? That is going to affect a child and how a child is raised, because there's going to be temporary placement. How much can we use that within the judge's decision? Because he did give that a fair amount of weight. And I assume, I'm sorry, I think the judge was a he. I'm not, I apologize if it was.
Yes.
It was, okay.
Yeah.
So what do we do with that? And I don't think case law has really talked about that much.
So I think that in terms of I don't think that there should ever be any bright line rule about, this number is suggestive. Obviously past patterns of behavior have prognostic value. I think more important perhaps is actually the inability to safety plan. So, a parent could conceivably have situations where they do need to receive that additional level of care. But to be able to have a plan in advance, these are the warning signs, these are the circumstances that I need to be on the lookout for. I find myself in that situation. I've identified these potential caretakers, because nominating another caretaker who is responsible is not evidence of unfitness. Actually, it's, responsible parenting. I think that those are the circumstances that would be helpful, and that was one of the problems that the judge found with mother's testimony, was being non-responsive to any type of safety plan. And I think even just being a little bit, I don't know, maybe unrealistic, basically saying that she would walk it out, that if she finds herself in that situation, to talk it out, where, the mental health is it's not that simple, and that there are interventions that may be necessary that, do require, several hands on deck.
So in other words, if somebody has these type of issues, and non-compliance is very common, as I'm sure you know with mental health patients, that if that occurs, she has a plan in place that the child will go to a relative or something like that. That would be evidence that a judge could consider in finding, but for non-compliance, there's a plan in place.
Right, I think, and that's what the judge focused on. And I believe, I think it might be conclusion of law 13, where the judge does at least address in part the safety plan. So basically, but beyond, having a plan of this is what's going to happen, to also then be aware of, those symptoms or those behaviors that precipitate the need for that plan to be implemented. And so that insight, that developed insight into what are the behaviors, what should I be looking for, where I will need some extra support to be able to safely take care of this child. These medications do have side effects, and it's sometimes difficult for people to maintain that regimen, but the issue is that there was stability with them, but then also being able to have that insight to plan ahead. These were the judge's concern. So while nothing, thankfully,
nothing seriously occurred while the child was in her care or when she was visiting with him and not taking the medicine.
He doesn't have to wait for disaster to strike.
Right. Like basically,
so
yeah.
can I ask the post-termination visits, does the department have a position on this, noting that the judge, I think I'm fairly characterizing the record, didn't make any findings about this finding, or about this ruling? No feature.
No, and I did check, there's the conclusion of law where basically the judge would use the opportunity to speak to the bond with the parent and the reason for the need for visits. It's not apparent from the conclusions of law. I could not tell you whether or not this was a request that was made at the time of trial, so I don't.
I actually can. So
Okay.
volume 6, page 33 of the transcript, this is the child's lawyer, mother's lawyer. The visits with with mother and child, if this court is inclined to terminate her parental rights, which we strongly object to, that there is not enough basis here to do so, that post-termination and post-adoption contact be ordered at least once a month. So, in fact, trial counsel did request that, and in spite of that, the judge didn't make any findings. Now, I mean, the judge did a huge amount of work here. I'm not trying to criticize the judge. I'm just saying there are no findings on this. And so, best interest of the child, she worked mightily to maintain a bond with her child. I'm not an expert on whether there was a bond, but I didn't see evidence of a lack of a bond. I saw it as a toss-up. And so the judge could go either way, is all I'm really saying, but there's no factual findings here. That's what I'm saying. What's your position?
I couldn't tell you. I have not asked the social worker what the clinical position is on the current contact, but I do understand from the ruling that basically it is left to the discretion of the pre-adoptive parents.
Yes.
And, you know, I don't know if my sister could probably give you some more current information if you guys did want to go outside the record, but being that these are family members, I believe.
We can ask them.
Yeah.
Thank you.
Thank you.
Thank you, Counselor. So we now will hear from the child.
May it please the court, I'm Sherry Krasner here on behalf of the child. My client came into care when he was 5 weeks old. He will be 5 years old on his next birthday. And while I appreciate the attention that this court gives when such a fundamental right is at stake, I would also ask the court to balance that against this child's need for permanency. Let me skip right to this issue of the post-adoption visitation. So the judge in conclusion of law number 28 does talk about leaving visitation to the discretion of the adoptive family. So under adoption of Alona, this is something he can do if he first makes the determination that visitation is in the child's best interest. He can then, if he believes that the pre-adoptive family, the adoptive family will act in the child's best interest in making those determinations, he can do that. So I would suggest there's no problem or no error here. Perhaps he should have more clearly discussed the fact that a continuation would be in the child's best interest, but I don't think he failed to do his duty in leaving it to the discretion, given that this was family, given that there was a relationship, given that for the first year and some months that the child was in care, that the pre-adoptive family was willing to afford mother very generous visitation. Talking about care and protection of Bruce, I think there are very many things that distinguish this case from that case. In Bruce, the mother had 2 years prior to her acute psychotic episode in which she provided adequate care for the child. So, and even during the time that Bruce was in care, the mother was caring for other children. She was caring for her sister's children, and she also was meeting with Bruce's providers, and the testimony was that she was able to understand, assimilate that information, and use that information in child rearing. In this case, the child is not mother's only child. There was another child that she had, and her care of that child was not adequate and that child had to come into care. So I think that's one thing. There was a history. There wasn't simply that speculation. There was a history of mother's inability to provide for the care of her older child.
Well, I mean, it's not your strongest argument. I mean, mother, it was a long time ago, and she maintained custody, I believe, until the child was a teenager and the father took the child. I mean, I'm aware of the episodes, but it wasn't perfect, but it also wasn't particularly probative.
I think there were some reports of mother's care for the child that suggested her paranoia, and I think some of that paranoia was still in evidence.
That's a fair characterization. I agree with that.
Later on. So again, the point is not as much the specifics, but the notion that there was a history from which the court could prognosticate. Also, too, there's nothing in Bruce to suggest that that child had any special needs. My client has clear special needs. And mother's, although to her credit, mother at court did not deny that the autism diagnosis existed. She said she wanted to get a second opinion, but she didn't deny it. But she downplayed the notion of the sickle cell trait, and she also suggested that the child had some other conditions that there was no medical evidence or no evidence that supported that. So
Can you speak to the evidence of bonding?
I'm sorry?
Bonding, evidence of bonding. Mother, the child is really lucky to have the maternal aunt. I think there is positive evidence of bonding there. I'm interested in that. The record seemed a little muddy on the evidence of bonding between the mother and the child.
Mother, as this court has acknowledged, to her credit, showed up for weekly visits, and let's also acknowledge that DCF does not always continue to provide weekly visits after there is a goal change. In this case, they changed the goal from reunification to adoption in, I believe, November of 2022. Yes, the child came into care in July of 2021. Goal changed in November of 2022. Trial wasn't until August and September of 2024, but yet the department continued to provide weekly visits to this for mother and child. That does not always happen. Sometimes when the goal changes, they cut back on visits significantly, but
sometimes the parent gets so angry that they walk away. I've seen that, and that didn't happen here. I was struck by that the department changed the goal. I've already said this, but mother kept coming back. And that to me is at least evidence from her point of view of a bond. But I know that the question is appropriately the bond, evidence of a bond for the child's best interest.
Mother came to many visits, and there were many visits in which mother was appropriate with the child. But that is not the whole story. There were times, and the evidence talks about this, where she was harsh with the child, where the child was 2 years old, and she tried to feed him a whole banana, and she said he should be old enough to be able to do this. So this wasn't a perfect record in terms of mother's ability to provide for the child. It's also within the confines of that visitation room at DCF or at a Wendy's or a McDonald's where they had some of those other visits, if she would be able to provide adequately or provide minimally acceptable care. To speak to the issue of whether my client was bonded with his mother, there was nothing to suggest that he was not. But again, too, the judge implicitly made a determination that it would be in the best interest of the child to continue to have visits with his mother, but he left that decision to the pre-adoptive family who knows the child and knows his needs. I see that I only have a few seconds left, so I'll rest up my brief and thank the panel for its time.
All right. Thank you, Counselor. Thank you all. We'll take the case under advisement. I'll call the last case of the day, Carpenter versus DeMarco, 25P33. Counselor, whenever you're ready. Actually,
Good
hold on.
afternoon, Your Honors.
Hold on a second, the clock
Oh, I'm sorry.
is struggling. Ah, there we go, okay.
Perfect. Good afternoon, Your Honors. May it please the Court. Robert McLaughlin, Jr., along with Mark Colton, counsel table, on behalf of the plaintiffs' appellants, the Carpenter Trust trustees. Let me very briefly say that the Carpenter Trust is an asset-based lender, and what that means is they are looking to get paid back on the equity in the property, not necessarily the creditworthiness of the borrowers. And in that calculus of loaning money, foreclosure is always on the table. You may have to foreclose, you may have to do it. Very briefly on the facts, I just want to touch on a few here. I know you're very familiar with them. When this loan was made, they knew there was a $750,000 first mortgage. They knew that they were loaning $180,000. And they also knew that the fair market value of the property was $1.435 million because there was a signed purchase and sale agreement on the date this loan was
Right off the bat, there's so many questions I have, but the $750,000, they were behind on payments.
They were.
And I don't know that we have in the record, I didn't see it, the interest rate, but given that your interest rate was 18%, I'm guessing their interest rate was also pretty high. So was it, how much was owed on that $750,000? It might have been more than $750,000.
So it was more than $750,000 for sure because it was in default. We don't have on the record exactly what it was.
At the time your client chose to get involved in this?
Yes. And two facts to be clear of. If you look at those numbers, there's $300,000 or $400,000 of equity to play with on those numbers of $750 plus something else. And also the first mortgage.
Right, but my point was, it's less than that because there's also interest owed.
There is interest owed.
So there's less equity than that.
It's you can back into it in the record when you go to the bankruptcy court findings and they make a finding of what's owed during that period of time. I have not done the math to back in, but you can back into, there's a per diem in the findings in the bankruptcy court. You can back into it to do it. Nonetheless, it was nowhere near $300,000 of interest that was owed at that time. And it was a first mortgagee who was known very well to the the Carpenter Trust because they knew who they were. So I say as they went into it, what did they knew? They knew they had some real equity and real ability to get paid. Massachusetts is a title theory state, and with a title theory state as a mortgagee, you were going to get actual title to the property. The owner...
R&R's got the title, right?
So you get what the owner has left to give, which is a second title. You get the same title that's left for the owner to give you, and you get the priority of being behind R&R. So you still have the same title, you have the same rights to foreclose under the foreclosure statute, the ability to exercise that title.
Right, so R&R has title, and you also have title if you're a second?
We have title subject to R&R's position as the first mortgagee and their title rights. So we have a title as to what is left over from them in the property, and we are granted a title interest, and like any mortgagee, we have the ability to foreclose. As a second mortgagee, of course, it would go subject to the rights of the first mortgagee, but the ability to close and do so. And the title here is critical because it's the essence of what you get as a mortgagee. It's how you get paid. It's the power of sale that you have under the statute, and that's 183, Section 21. The symmetry that you will see here is what do you get for insurance? What do you get for a title policy? Well, you get what you have to be protected, and that is you get the title, your title, protected in the priority in which it has.
Right, but you don't get, this is important, you don't get a title search. You don't get the promise of the title company to go find this attachment that was floating out there, right?
They didn't give a title, they did not give a title certification.
Sorry, let me push back on what you said, because I'm looking at the mortgage title insurance policy, and it says title is vested in the trustees of the Cross Street Realty Trust, and what's insured is a mortgage in the principal amount of $180,000. I don't see where it says that your subsidiary title is insured.
With a mortgage, you get title because we're a title theory state.
Maybe you do, but I don't see where the policy says that's what's insured. It seems what's insured is your mortgage.
It doesn't. If you go to Schedule A of the policy, I mean, it tells you, and let me just go a little bit higher up on it. We start with covered risks, and what is insured under covered risks is subpart 2. Any defect in...
What page of the record are you citing to?
I have it as the addendum. It's probably the easiest place to look at it. I can actually pull my copy in. It starts at page 78 of the addendum. And if we go to what's covered in the the schedules, and if I can bear with me for just a minute, I'll try to find the provisions which aren't coming up immediately. But in any event, it is under the covered risk section of the policy. Subparagraph 2, it's any defect or encumbrance to the title. That is covered. And it is the lack of priority, this is subpart 10, of the lien of the insured mortgage. What does title mean? Well, we have to go to the policy and find that out, so we go to Schedule A. And Schedule A of the policy defines title as the fee simple interest in the property. So we know we have title protected in the fee interest. And then the insured mortgage, of course, is the Carpenter mortgage. And there are exclusions, of course, and those exclusions are the first mortgage, and, which is significant here, of the mechanics lien and the assignment of leases.
Right, but the title is the title in the trustees of the Cross Street Realty Trust. If there's a defect in that, obviously that's going to be a problem for you too. But that's what seems to be insured under Schedule A.
So they're ensuring that I have title.
Where is, I don't get that. I don't see that.
So, and the issue here, if I may respond, Your Honor, is there is no issue that the title is clear for the trust that granted, the Cross Street Trust granted the title. That wasn't the issue. The issue was there was an intervening attachment that came in that we were protected from. That's what the insurance policy covers. Our priority
and they did protect you from it. This is, what I'm struggling to understand is, to bottom line it, how would it have been, I think your argument is broadly that, yes, you did move us back into the second in line where we were supposed to be ahead of the attachment, but if you'd done it sooner, things would have been better, we would have made more money. And putting aside speculation, why is it their duty where is their duty to do it sooner?
Their duty to do it sooner is, their duty is to do it first off, which is they have to do it all as insured, okay? So they have cure rights under Section 9, and their cure rights allow them with some ability to essentially put us back in the same position, their cure rights. If they don't do that, I'll get to time in a second, if they don't do that, we don't get to time. And now the question is, with the foreclosure that went through, can they restore us to title? And the answer is no. The foreclosure statute wipes us out.
Okay, I read that. I read it a lot of times. The reality, this is just about money. So the money, how can you prove that your clients would have gotten more money than the $6,600 if they had put you back in your right place in line before the foreclosure? Your opponent makes a very clear argument. The answer is it wouldn't have made any difference.
Let me tell you why. As a mortgagee...
Without speculating.
And I'm going to give you the evidence right to the point. And I will say this, I think we were we're giving adequate consideration by the motion judge who said it's plain speculation. Here's why it's not. These are absolute rights that a mortgagee has, first or second mortgagee, has the ability to, in our situation, we could have gone before the foreclosure, and we could have bought the first position. Again,
why couldn't you do that anyhow?
Because there's an intervening attachment. It
So?
makes no sense for us to do it.
I don't know why. I don't understand why. It's an attachment that's bogus. So you do that, and they'll still have this attachment, and you'll win the attachment. And in fact, it's the title insurance company that will litigate and get that attachment, and then you'll have all the money and the property.
Because the intervening attachment now makes it too risk averse for us to do it. And
Why?
frankly,
Why is that?
Because we have insurance for it. And the issue is, I'm looking to my insurance company to step in and take care of that
And your
issue.
insurance company says they will remove the lien. And that's what they did. All is insured. They removed the lien as insured. Why isn't that the risk you've done? And I assume they would have done that even if you had bought out the mortgage. They still would have gone and removed the lien for you.
So
And if they couldn't, they would owe you $180,000.
Let me answer this way. The timing, they were aware of this back in July, certainly by August, and that's the email from Attorney DeMarco to Caddick. It has all of the documents on it. They were certainly aware of it. They were certainly aware of it when Attorney Colton wrote them on November 13th and told them, and they did nothing. And they did nothing. And the assurance that we're supposed to have that the insurance company is going to step in and do something, they've done absolutely nothing at that point in time. As we go forward. Again, this is why we have insurance. We're transferring the risk of this for a fee, for a premium, over to the insurance company. The insurance company could have stepped in and done these things if they wanted to. But to put it on to us, it's too risk. We turned to the insurance company, we made our claim. They have their rights, but their rights are very limited by restoring us to our position that we are all as insured. Again, key words, all as insured.
All right, so they can remove your lien, all is insured. How did they not do that? Maybe they didn't do it quickly enough, but they removed your lien, all is insured.
Because when the foreclosure came, we lost all our ability to do the rights I summarized in my brief. Attorney Justice D'Angelo has a question. I'm happy to answer your question, Justice Wood, but I'd like to. But
I don't know if you were here for the other title insurance company.
I was.
Okay. A contract is a contract is a contract. I learned that first year, contract law. God help me. This policy had specific language as to how notice was supposed to be given to a particular address, not to an agent, but to the company at a particular address. That was not done. So why isn't that the end of the story here?
That was done on November 13th.
Well, prior to that.
That's Attorney Colton's letter. Because, and this is, I guess.
Because you do argue that prior to that they should have.
I do, and they knew. And I'll say this. Attorney DeMarco is clearly their agent. They try to disclaim him as an agent. Okay. They should have told us that early on.
I'm going to give you, let's just, I'm not, for purposes of this argument, they're the agent. That's not what the policy says. I'm a firm believer, the policy says this, you got to follow the policy. If you don't follow the policy, out of luck.
They absolutely have it on November 13th.
Okay.
They absolutely have it
So
then.
you're conceding prior to that, at least pursuant to the policy, notice wasn't given. It was given to an agent.
I will concede this, but I want to, and yes, I'm conceding that point, but I want to explain why, which is we only had part of the policy that is in the record.
Well, that's going to be a question to opposing counsel as to why that isn't a fact that might be an issue of dispute. You say you didn't have that portion of the policy. They said that you were on proper notice of having. So
yes, and that's the reason. What do I do as a mortgagee? As I have the ability, I can buy the first position and stop the foreclosure altogether, as long as there's no intervening attachment. I can go to the foreclosure sale. I can bid my paper in as a second mortgagee. If someone comes in and outbids both of us, I get paid. If they don't,
Why can't you, Justice Ditkoff's question, all of these are, you could have done that anyway, and I think you say it didn't make financial sense because of the attachment being there. Yes. And we keep saying, or at least I keep saying, you could have looked at the attachment and figured out very quickly it was bogus. And so it sounds like you're saying, as long as there's an attachment, we're not going to look at this at all. And we don't have any obligations. And that changes everything, and we couldn't take any self-help. But your client's a sophisticated operator. Like, that seems to me unrealistic and unreasonable.
So instead, we put our insurance company on notice and said, we're making a demand that you take care of this problem for us. And that was it. And they could have done those same things, but again, for us to put the money at risk is what I'm saying.
But if we find that the insurance company did their job reasonably fast enough and well enough, then what's your argument?
The argument is they didn't, number one, restore us to all as insured. Words matter in a contract. This is what we bargained for. What does the objectively reasonable person expect that contract to say? It says what it says, that they would restore us under Section 9 to the position we had before. Post-foreclosure, they could not do that as a matter of law. Let me address the diligence aspect of it, because I think it really is looked at both ways. Diligence, Caddick will tell you, gave us a reasonable time to take some actions. I look at it from the other way. Diligence was you had to act within a certain period of time, and if you didn't do that, then that is a limiting factor. It's not an expansive factor from their side of the view. It's a limiting factor from our point of view, and they clearly didn't do that because, again, it is limited by what happened while the foreclosure still comes along.
Let me ask another version of the question. Putting aside your I call them speculative, but you call them something else, ideas about how you would have rearranged this deal if they had done this more quickly. Assume for the sake of argument, just assume for the sake of argument my question, that they did this before the foreclosure, and then there was a foreclosure anyway, because R&R went ahead and foreclosed, as they're allowed to do in the first position. Assume those two facts. Would it have been any different? Because how would it have been different?
Because we would have bid into the foreclosure to protect ourselves. Best R&R can do is get paid in full, and if they went through with their foreclosure sale in your thing.
What would they have not gotten? They had their loan amount, their interest amount, and their legal fees and costs. And why is any of that? And then you're left with $6,000. What of that would not have been spent if you'd been in this foreclosure proceeding?
So the two facts I want to focus on, one is the foreclosure sale price was about $1.1 million. And again, in the record, the fair market value price, which I think is a solid fair market value price, it's a signed purchase and sale agreement, was $1.435 million.
But the assumption of my question, sorry, is that they ran the show. They moved for foreclosure. That's what happened. There was a sale for $1.1 million because they did the foreclosure, as they're allowed to. How do you get any more money?
We would have bid in and bought the property. And then we can sell the property in that fair market value, $1.4 million, at a commercially reasonable sale. That is the difference here. That's how we protect ourselves. And as I started the argument, that's what we bargained for. We made the loan.
Let's say the second they could even have known about this in July, they jump into action and move to eliminate the attachment. It took over a year to get the attachment out once the lawyers got involved. Where's the evidence that it was even possible to get the attachment done before the foreclosure sale?
Well, they didn't file the motion until April, after the foreclosure sale. April 20th.
I understand. From the time of the filing the motion to them succeeding is over a year. It's a year and almost 4 months. So how could anyone find that they could have succeeded before the foreclosure sale if they had started back in July with a motion?
The answer is if they couldn't, then they couldn't. They couldn't exercise their rights to, and again, it's a two-step analysis here under Section 9. They have a period of time in which to do so, and they have to get results. They have to restore us to the position that we bargained for.
Sir, I want to make sure I understand what you're saying. You're saying that, let's say that in August 14th, whatever, that when Attorney DeMarco got that email, they immediately started moving. And they, in all good faith, worked as fast as they could, but they couldn't get it done by the first foreclosure date. Then you're saying that you would collect from them?
I'm sorry,
sorry.
You win then?
You win if they've done their best to move on this and haven't gotten it done. Justice Ditkoff's point is the inference is that it takes at least a year or maybe 10 months. But in other words, there's no way, let's assume there's no way they could have gotten this done before the foreclosure. And first, and R&R does the foreclosure. You're saying, even though they try their best, if they failed to get it done, then we win.
These are cure rights that they have. They're limited by the terms of the policy, what their cure rights are. Their cure rights are they have to restore us, all as insured. Number one, they didn't do that. And if they did the best they could, again, I look at the diligence.
It says they had to remove the lien, all as insured.
To remove the lien and put us back in a position.
Doesn't say where does it say put us back in the position? It says remove the lien, all as insured in a reasonably diligent manner.
So when you put together, remove the lien, you put together all that, and all as insured is the controlling language at the end of the three different things that they can do. They can establish title, they can remove the lien or encumbrance, or they can establish the lien of the mortgage insured. That is all as insured. We were insured as a title position and a second priority on this property. In order for them to comply with their cure rights, they have to restore us to that position. And as I said before, they cannot do that as a result of the foreclosure.
All right.
In response to your question, again, looking at, Justice Wood, your last question, looking at the time frame here, it's a limitation. It's not an expansion. The limitation of time is, from the insured's perspective, you have a limited time in which you can try to, this is a CADIC, can exercise its cure rights. And if they don't exercise it in a limited time, and here's what happens, is the limited time is the foreclosure sale that comes along. They haven't satisfied their ability to do the cure.
Thank you.
Thank you, Your Honor.
Thank you, counsel. We will hear from the insurance company. Whenever you're ready, Counselor.
Good afternoon. May it please the court, Danielle Long for the defendant, Connecticut Attorneys Title Insurance Company, who I will abbreviate and refer to CADIC as we're going through this argument.
Please do.
Just a few things before I jump into my argument, and I'm sure you will have lots of questions. As my brother started out, they are an asset-based lender looking to get back on its investment. Title insurance did not ensure that they were going to get back on their investment 100%. Another point I would like to make is any loss and an insurable loss under the policy are two very different things. When this lawsuit was initiated, there were two defendants. It was Attorney DeMarco in his law office as well as us. Although the trust did not succeed on summary judgment, they claimed, as alleged in their complaint, that they hired Attorney DeMarco separately to perform a title opinion and to represent them at the closing. And DeMarco was also representing the Carpenter Trust at the closing. So he was wearing several different hats.
And he was your agent for issuing title
And he was our
insurance.
agent, but he was our agent for the, and that's typically how these closings
For issuing.
Correct, for the exclusive role of just issuing a title insurance policy. So yes, DeMarco, I think I just said 4 different roles that Attorney DeMarco had. Also too, Caddick afforded coverage. We got the claim, we accepted coverage, and we provided a defense attorney immediately.
And I assume your position is that you got notice when you got the letter in November. Is that right?
Correct, because I'm not exactly sure whether the trust position is DeMarco provided notice as our agent or DeMarco provided notice as an attorney for.
Right.
But it doesn't matter. Either it doesn't matter because actual notice doesn't supersede the provisions 3 and 17 of the policy. It had to be sent by the insured to Caddick's corporate office in writing.
So let's get back to that. I told
Sure.
you it was coming. According to the Zimmerman affidavit, they say that they did not have notice of the provision about where they had to send the notice to. You say they did.
Yes, but
Isn't that as a genuine issue of material fact?
it is a fact that is not relevant, and I actually pulled it from my brief. I mean, also in that jacket of the policy was coverage for the lien, and so then they would not have coverage for that as well. I guess you can't really have it both ways, but there's a footnote.
They could have, I mean, they probably knew they had title insurance, but they may not have known the specifics of what address a notice had to be sent to.
So if you look at my brief on page 35, I have footnote 4, and I cite a case, and I believe the Superior Court actually relied on this case as well. Neither delivery nor actual possession by the insured of the insurance policy is essential to the making of an insurance contract unless the policy expressly sets out a requirement of delivery, and our title policy does not. It's undisputed, it does not. And the case is Gargano v. Liberty International. It's a federal case interpreting Massachusetts law. So that's in footnote 4 of my brief. Nonetheless, there's testimony in the record of Attorney Zimmerman, who really conducted all the business for this trust, and it was his daughter and his wife who were the trustees, that, he's been doing this for decades and decades, and he even testified, I don't even read these things. I know what title insurance does. I got whatever DeMarco gave me. But in the end, it is not relevant, and it's not a question of fact that goes to the ultimate finding, because even if you go through all the coverage arguments and what we did and how we complied with Condition 9A of the policy, there was no actual monetary loss incurred by the trust.
I don't get that, because if the original sale had gone through, they wouldn't have lost any money at all.
So again, I'm going back to the difference between an insurable loss and an actual loss. Yeah, I mean, no, I don't disagree that the trust.
You're insuring their $180,000 mortgage against, among other things, a lien or attachment. And because of an attachment, they don't get the sale to going through, and so they don't get their $180,000. Now, I know you've got your 9A, a cure of that, but it seems to me until we get to 9A, they've got a loss.
They do have a loss. I'm not denying they have a loss.
An insured loss, a loss that's right there on the title thing, the $180,000 mortgage benefit against attachments, and it's attachment that made them lose it.
So and that's exactly right. It is, if the attachment was not subordinated, then they would have incurred a loss that was covered by the policy. So let's start with the initial fact. The foreclosure occurred. It's a fact. We didn't insure, We accepted from coverage that first mortgage. It's a second mortgage. So when that foreclosure occurred, the title policy was not obligated to prevent the foreclosure of a first mortgage it did not insure. So the foreclosure is not the covered event. The covered event is the attachment. So foreclosure occurs, and then now what's left. If that attachment was not subordinated to behind us, that is the covered matter.
See, that's what confuses me, because it seems to me that you need to beat the lien in a reasonably diligent manner. And the judge specifically says, I'm not even reaching reasonable diligence, and I don't get that step. I understand if you subordinate that lien, which you did, in a reasonably diligent manner, and that we could discuss, then no liability. But it seems to me if you didn't do that, that there would be liability.
But again, you have to focus on the strict language of the policy, which is condition 8. Actual monetary loss for a matter insured by the policy. The policy does not insure all these hypothetical scenarios. Well, if this happened, if you dissolve the lien, is it a day before the foreclosure?
Well, I get that, but why isn't losing the $180,000, which was lost because of the attachment, an insured loss?
It was lost because of the foreclosure.
Well, I don't see why is that something we have to get? Because this record, there's several affidavits that say that there was a sale that fell apart because of the attachment, and if that sale had gone through, they would have gotten paid completely, and they would have had their $180,000 back. Seems like at least a jury issue that the attachment cost them $180,000, not because of the foreclosure, which wouldn't have happened if the sale had gone through, but because the attachment killed the sale.
So overlooking the numerous issues that we moved to strike with, the supporting evidence for why that sale did not go through, it's all hearsay. There's no evidence from the actual buyer or seller why that sale didn't go through or why the mortgage actually foreclosed. Again, bringing it back to the strict terms of the policy, we did not insure the foreclosure of the first mortgage. It does not matter why that did not foreclose.
But you insured against an attachment, and the attachment prevents the sale, which is what cost them ultimately the $180,000. I don't know why you keep going to the foreclosure. The foreclosure doesn't cost anything. They're going to get, those R&R people are going to get paid no matter what. It's the loss of the sale, which is caused by the attachment, at least on the non-struck affidavits.
So hypothetically, then we're saying the policy is supposed to cover the potential, and I think Attorney Rainin, their expert, had said, potential strategies and opportunities to negotiate with the buyers or try to prevent this foreclosure.
I'm not saying that.
It's not an actual monetary damage.
The affidavits here say that there was this sale that fell apart because of the attachment, and if the sale happened, they get all their money. Nothing about what happens afterwards of the foreclosure sale. I'm not talking about that. I'm talking about there was an original sale that was set up, not the foreclosure sale, and it fails because of the attachment, at least according to these affidavits. And if it doesn't, and that's what causes their loss. They don't have any loss if that goes through. I don't understand why that isn't insured by you. I understand why, this thing about them, grabbing it at the foreclosure sales is not something you're insuring. But I don't understand why that isn't insured. Again, you still have 9A, but.
So under 9A, there was several different options we could fulfill to satisfy 9A of the policy to fulfill our obligations and not be liable. And one of them was, let's see, either remove the defect, and there's several ors in there, or establish the lien of the Carpenter Trust mortgage all as insured. We established that lien. We established the lien of the Carpenter mortgage as insured as a second mortgage. I mean, if that was the scenario.
You did, so isn't the question whether you did that in a reasonably diligent manner? Isn't that what it comes down? Because if you did that not in a reasonably diligent manner, 9A doesn't help you, right?
Well, yes, within 9A there is that language, but again, I believe the Superior Court was proper, you don't even get to whether it was done in a reasonably diligent manner because they have no insurable loss under the policy. But even if you did, that is an issue for expert testimony. We submitted unrefuted expert testimony that we acted in a reasonably diligent manner. They had an expert, Attorney Rainin, who very interestingly did not offer an opinion on whether or not the title company acted in a reasonably diligent manner.
So your expert, which was Attorney Hurley, right?
Correct.
His opinion seemed to be based on the premise that November 13th, 2015 is the date that he judges reasonable diligence from. Am I missing that?
Correct, because that is when Attorney Colton sent the formal notice. And I can walk through, because I believe some of the dates were incorrect.
Right, no, but it gets back to the question of, is that right, that November 13th is the moment that matters, or does the August 14th date matter? Because I don't see Hurley opining on that.
No, the August date, because there was no notice under the policy in August. The operative date for when that claim was filed was November, because, I mean, there are certainly circumstances where an agent may be like, hey, you know, this may be this may be coming to your plate. There may be a claim filed here, and sometimes the claim is filed, and sometimes they work it out amongst themselves, and a claim is never filed. But when that initial claim was filed in November 13th, the claim was acknowledged a week later. There was back and forth. Caddick didn't get the information in the response from the trust until December 30th. And now we're in the holidays here, and on January 14th, Dina Swanson was retained to represent the trust. 5 days later, she files the emergency motions. She couldn't just move to dissolve the attachment because she had to seek relief from stay because there was 2 bankruptcy proceedings. I mean, that was the whole issue, this attachment. The whole unfortunate circumstance of this is the attachment should have never went on that property in the first place. So she did that, and then also, too, I think there was, my brother had said she didn't file the motion for relief until after the foreclosure, but she had to get the relief. The relief was granted March 7th and March 25th because we had 2 bankruptcy proceedings going. And then the first mortgagee files an adversary proceeding because the creditors in the Lyons lawsuit are challenging the validity of the first mortgage. Of course they are, because their attachment is going to get wiped out by that one way or the other. So then we had to sit back and wait for those proceedings to take place. Caddick couldn't control that.
Can I jump in and ask a question?
Sure.
I think that is part of the answer to my question. There's $47,000 in legal fees and then $49,000. So there's supposed to be $100,000, and that just starts dribbling away.
Yeah, and that was mainly from this proceeding.
Right, and that has nothing to do with your delay. That's your position? That the loss of those fees are because of a fight between R&R and the people who had the attachment. Is that what, am I right about that?
Well, one, my position is there was no delay, and 2, and I know the significance of not insuring or accepting from coverage that first mortgage is very, very important and essential to our argument, because if you could, if the title company was obligated to prevent the foreclosure or offer all these other strategies for the second mortgagee to try to prevent the foreclosure, you would never get a title insurance policy on any second mortgage ever. Because think of all the risk that would entail. You have to stick to the policy. The foreclosure happened. It does not matter why it happened. We didn't insure against if the first foreclosure happens for this reason, we'll insure you. If it happens for this reason, we won't insure you. It's a fact. It happened. When it happened, was the insured, did they experience an actual monetary loss for the insured matter? When those proceeds were distributed, the attachment was subordinated. There was no actual monetary loss.
Your definition is if money had been somebody wrote a check to the people who owned the attachment. That's your definition of a loss to the attachment. The insured loss is to a loss is to the attachment, meaning money going to the folks who have the attachment instead of these folks.
Their loss would be if they experienced a monetary loss because their priority was less than as insured. When they were paid out, their priority was as insured. And I really think you need to focus on Condition 8, that language of the definition of the loss. Again, we're not saying there, of course there was a loss here. The question is, was it an insurable loss? And the loss, we did not insure the loss from the foreclosure. A mortgagee's policy does not guarantee that you get all your money back.
All right.
I think I'm done. Yeah, I think I'm done. Yeah, any other questions?
Thank you. Thank you both. We'll take the case under advisement. I'd like to thank our court officers who keep us safe here. I'd like to thank our timekeeper, clerk's office, of course, without which we can't do anything, and all the attorneys who appeared in front of us. And with all of that being said, we will stand adjourned until tomorrow at 9:30 a.m.